attorneys for the state and all the attorneys for the defense, as well as each defendant is present in the courtroom. Counsel, you wanted to address the court?
Yes, Your Honor. We filed a motion on behalf of all of the accused in this case. It's titled Defendant's Motion in Limine and the Alternative to Permit Limited Reference regarding Graham v. Connor and expert reliance on federal objective/reasonableness ruling and supporting memorandum of law. And this motion, Your Honor, is based on the 5th, 6th, and 14th Amendments to the U.S. Constitution, Article 1, Section 10, and Article 1, Section 19 of the Texas Constitution, and regarding our right to compulsory process to present to the jury our right to a defense, and because of our right to a defense, our theory of defense, and we would cite to the court the 5 leading U.S. Supreme Court cases in that regard. It would be Washington v. Texas, South Carolina v. Holmes, Chambers v. Mississippi, Brock v. Arkansas, and Taylor v. Illinois. And what we're asking is that, I believe it's our next witness, Lieutenant Butch Majeka, who's going to be testifying, and as an expert, we're proffering to the court that he is an expert in this field, that he's entitled to rely on the literature, the pertinent literature, the pertinent case law in the field, and obviously because he's an expert, he can rely on hearsay as long as it's reasonable, and experts in the field would rely on that in proffering their opinion in the case. And also, we are asking the court to consider the following under the rules of Texas Rules of Evidence 101, 102, 103, and 104. The first thing, and the court has a copy of the motion with it, and we are putting forward to the court that the Texas reasonableness standard is an objective inquiry, and under 1.07A42 of the Texas Penal Code, reasonableness is the same as it's defined in Graham v. Connor. And we want, particularly when you're talking about the actor's reasonable belief that deadly force was immediately necessary to counter unlawful deadly force under 9.32 and 9.51, both of which specifically, or 9.51 specifically speaks to a police officer's right. And we cite a case in there where Texas courts have recognized Graham v. Connor in that regard. Reasonableness from a reasonable officer's perspective is cited Graham v. Connor, and the analysis confirming the same framework in Texas excessive force or a self-defense evaluation. And also, the court has recognized when we cite a case there that the Texas doctrine also embraces the doctrine of apparent danger. Number 2, Graham v. Connor articulates the same operative objective reasonableness test used by police practices, experts, and courts nationwide. And for that, I would cite to the court, I would bring to the court's attention 2 things, again under rules 101, 102, 103, and 104 of the Texas Rules of Evidence. We've given a copy of the defense's, their designated expert, Mr. Chuck Joyner. In that, in his opinion, which the court has a copy of, he cites repeatedly reliance on Graham v. Connor and how it is controlling. We've also attached sworn testimony from San Antonio Police Chief William McManus in an arbitration case, Vargas versus the City of San Antonio, where you can see from the litany, the transcript, Your Honor, that Chief McManus, under oath, acknowledges that Graham v. Connor is taught to San Antonio police officers at the San Antonio Police Academy, and we've got the full transcript should the court want to look at it. Then we go on and to talk about under Rules 703, 704, and 705 that the expert, particularly Lieutenant Majeka, can rely on such materials, but the court is going to control on how these materials reach the jury. So at the end of this, we have a proposed order if the court wants to consider on how the court, what vehicle the court wants to use to allow the jury to hear, but we're asking for the court, for Lieutenant Majeka, because he is an expert, to be able to rely not only on Graham v. Connor, but because the reasonableness of the officers' actions and their beliefs are directly an issue. That is the crux of the case. Use of force is the crux of the case, which is exactly what Graham v. Connor goes to. And because he's an expert, he's entitled to rely on it. And under Rule 704, because many objections have been raised by the state, Rule 704 says an expert can embrace the ultimate issue in the case. So there's nothing prohibiting Lieutenant Majeka from rendering an opinion, assuming the court finds him qualified, on the ultimate issue in this case, which is, were these officers, were their actions, did their actions comport with a reasonable belief of a reasonable officer at the time the deadly force was required to meet an unlawful use of deadly force. And we've got in there how the state says that there's a different legal standard under Texas law and federal law, and our contention is that that confuses the binding effect with relevance, as expert bases, and ignores that both federal and state use the same operative objective reasonableness standards from an officer's perspective. And we talk about the Texas, obviously, their definition of a reasonable belief, or the reasonable belief in protection of a third person. And once again, that this objective assessment is precise. You look at it from the vantage point of the officer accused, and obviously the San Antonio Police Department also instructs officers in the dictates of Graham versus Connor, as Chief McManus's sworn testimony indicates. So we do have the proposed order at the end. What we're asking, Judge, is in this motion in limine for Lieutenant Majeka to be able to opine about his opinion with regard to Graham v. Connor and with regard to the federal decision in this case, which looked at all of the video evidence, like this jury has multiple times and the court has, and found that these officers acted reasonably. And again, Your Honor, that federal judge was using a lesser standard than we're using here in this case, but the inquiry is the same. Were the officers' actions reasonable at the time the force was used? Now the court can say, hey, I don't want you to necessarily say this was an opinion out of the Western District of Texas by Judge Fred Beery or the magistrate, Judge Bemperard. The court can say, or he instruct Lieutenant Majeka to say, another court has, informed me my opinion. I relied on a recent decision of another court which found that under these exact same circumstances, their actions were reasonable at the time the deadly force was required. And for those reasons, Your Honor, we would ask the court to grant our motion in limine and allow Lieutenant Majeka to testify in the way I've so requested.
Your Honor, first of all, the opinion by the federal court, which is titled Report and Recommendation by a Magistrate, is not Supreme Court precedent. It has no presidential value. It is, I would dare say, not a case in that form and in that status, and it's still being appealed and being done final judgment. Has no relevance in any training to police officers and police academies, or these police officers in particular, of course, because it happened when this happened. Their training is well before then. Also, it would be a comment on the weight of the evidence for the defense expert to purport to say, under identical facts in a unpublished, unreported opinion of a magistrate in Bexar County, Texas, that these officers' actions were reasonable. That would be an improper comment on the weight of the evidence. I submit to you, if you've not seen this case already, Court of Criminal Appeals case Watts versus State, 99 Southwest 3rd, 604, which is a judge taking judicial notice of a fact that water had been described or a drainage ditch had been described in some way in another opinion, and so the facts in that case had the drainage ditch was in the same condition, and so they were saying that opinion controlled over the definition of a drainage ditch. The court said that was an improper comment on the weight of the evidence. That case was reversed for that reason. What defense is trying to do, and I know we've been accused of backdooring things every day in this courtroom. It's their attempt to backdoor a way of getting in an opinion that has, one, no relevance to this case, given the fact that it's a federal standard. It's not a criminal case. It's a civil case based on the Fourth Amendment and the right to pursue a 1983 action. It only involves 2 of the 3 defendants. And so it's not relevant at all to one of the defendants. They've chosen to try this case together altogether. You can't have evidence that's relevant to 2 and not all 3. And it's incumbent on the weight of the evidence. And it's improper for a person, simply because they designate him as an expert, to be able to speak about court opinions and the facts of court opinions. There is an opportunity to use hearsay by an expert, in the sense of it can use him to develop what his opinions are, but he can't just state everything he's read or everything that he's heard. But the rules call for is the opposing party to ask if they wish to about the underlying data. But it's not for the person sponsoring the expert to just go into hearsay as they propose to do. We would also ask, as we did when we filed our motion to eliminate at the beginning of the state's case, or the defense case, to have this witness testify outside the presence of the jury on the matters he expects to testify to in Rule 705.
Your Honor, may I respond?
Yes.
Your Honor, we're not asking the court to take judicial notice of the federal court opinion. What we're asking is for our expert to be able to say what he has relied on, the numerous things he's relied on in order to reach his opinion. That's very different from us asking the court to take judicial notice of it. So we're not asking the court to do so. The court is not commenting on the weight of anything. Secondarily, it's disingenuous when we've got sworn testimony from the chief of police of the San Antonio Police Department when they filed a motion in limine saying Graham v. Connor cannot be gone into, when number 1, their own designated expert says Graham v. Connor is controlling of these issues. Absolutely controlling. And further, not only does their own expert say Graham v. Connor is controlling, their own experts go on to say, Mr. Joyner goes on to say, tactics have nothing to do with this. Tactics are not part of the decision in this particular case. And he said the arrest was legal, as the court has ruled. So, for those reasons, I would ask the court to grant the motion in limine and allow Lieutenant Majeka to testify in that regard. We're not asking the court to take judicial notice of the opinion, but as an expert, he is entitled to rely on hearsay. That is like saying, I have an opinion, but I can't rely on Miranda v. Arizona because it's hearsay, because it's a court opinion. An expert can rely. Now, if the court finds that what he's relying on is not reliable, it's not relevant, that's another issue. But I think and another reason, really, that this should be admissible is because since voir dire, Your Honor, the state has gone through 3 or 4 different theories of this case. And this jury, unfortunately, has heard 3 or 4 different theories of the case.
We're on the same page. The state's opened that door.
Okay, and because of that, there's issues of confusion and misleading this jury, and I feel it's necessary for them to understand what the ultimate issue is in this case and to keep their eye on the ball. And that's another reason we're asking for Lieutenant Majeka to be allowed to address that.
Your Honor, I'm not objecting to any discussions about presidential value of Graham v. Connor and the teachings of Graham v. Connor in the Supreme Court cases that talk about how officers can protect themselves or that kind of thing. What I'm objecting to is using the expert to testify about the facts and circumstances of this particular case that are set out in a memorandum opinion, and to think that you can have the memorandum opinion and the facts of that case come out and just say, we're not going to name it or title it. It is frankly unwarranted. It's not. There's no expert in the country that would use that opinion at the level that this opinion's at. That's not even a appellate level decision. It's a simple opinion that is under appeal that has no precedential value. If they're talking about Supreme Court cases, I don't have any problem with that, Your Honor. I do have a problem with going into the facts of this case under this theory of I used Graham v. Connor to evaluate, Graham v. Connor was used to evaluate a district court case heard by a magistrate, a few weeks ago, which is improper. We would object to that.
Well, number one, Your Honor, that court analyzed their decision under Graham v. Connor and Felix versus Barnes, which Mr. Cifuentes has cited numerous times, another United States Supreme Court case, a very recent one, I think it was released within the last year, has cited that to the court. That's number one. Number two, that's new to me. The record will reflect these two gentlemen filed a motion in limine with the court specifically entitled, "We couldn't go into Graham v. Connor." So for him now to tell the court, we have no problem with them going into Graham v. Connor, is disingenuous when they filed a motion in limine saying we should be prohibited from mentioning it. That's why we're approaching the court and doing it outside the presence of the jury.
Motion in limine means to approach, Your Honor, means to approach and get a ruling before those things go on. And so we're approaching here on this issue and having the court decide on the merits.
All right. I'll grant the defense motion in limine without making any specific reference to a particular case and allow the expert to testify to what we've talked about here. Anything else?
No, Your Honor.
We would like the expert to have the 705 hearing that we hear his testimony first and so the court can make a ruling on whether he's qualified and the matter is relevant.
Yes, we'll do that.
Can you tell us that?
No, just hold on. We're trying to get the computers.
I come prepared.
Just trying to file it every afternoon. This happens
Yeah.
every afternoon.
It's all because of the internet, huh?
Yeah, I do when I just like use it here, I will disconnect or something. See what that comes out. You want to check and see?
There it is. Thank you.
All rise for the jury.
We're gonna go late today. Y'all got the message?
Yes, sir.
Are we at your?
We're going to do this outside the presence of the jury.
Oh, is that the next one? What? Was there a rush too? Okay.
Yes, I'm sorry.
Well, we'll give y'all some exercise. We gotta all stay healthy during these times.
Everybody got your great notepad? Take a seat.
All right. Welcome back, members of the jury. Hope you've had a pleasant morning and a good lunch. Hopefully y'all have gotten the message. There's a juror. At least one of you needs to leave tomorrow by a certain time. I think 4:30 at the latest. So we're going to go late today. We're thinking till about 8 o'clock maybe. Kind of depends on where it all sifts out. Jury trials take a life of their own. You just kind of go with the flow. So we're going with the flow. Maybe about 8 o'clock. If you need a break, let me know. Now, where we last left off, Mr. Goss, we were still in your case in chief. I don't know.
Yes, Your Honor, and so as Officer Villalobos' case in chief, we would rest and we would pass it over to Sergeant Flores' case in chief.
Okay. And then Sergeant Flores' case in chief, you call your first witness?
Yes, Your Honor, we call Lieutenant Majecka to the stand.
Okay. Let me swear him in, and then we'll go from there. I'm going to swear him in. Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. And state you wanted a 705?
We did.
All right. Members of the jury, I'm going to give you that exercise. We'll let you know when we're ready.
All right.
Please be seated.
All right.
Just for the record, I want to make clear that Eleazar Alejandro adopts this witness as our witness in our case in chief.
Okay.
So we made a tactical decision to let Mr. Nisbet do the direct, but he is our witness and he's part of our case.
Yes, Your Honor, and it's our understanding that Officer Alejandro, their case in chief will still remain, and there may be somebody or not, but they still have their case in chief to do this as well.
Yes. All right, so if you can give us your name and spell it for the court reporter.
My name is Thomas Majeka, M-A-T-J-E-K-A, but you'll probably hear me referred to as Butch. That's what I've been called since I was 4.
All right. State.
Well into the afternoon.
Yes, we are.
How are you, Butch?
Good.
Can you give us the benefit of your training and experience and tell us a little bit about what you're expected to testify to today?
Training and experience, I've been a police officer for 47 years. I started in 1977, of course, went through the San Antonio Police Department's Training Academy. I served on patrol for 10 years. Half of that was a field training officer as well. In 1988, I transferred to the Police Academy and became the lead instructor for arrest, search, and seizure, the lead instructor in criminal law courses. I did a year internship under Detective Harry Griffin at that time to get myself ready to teach that particular course. I obtained an associate's degree in criminal justice from San Antonio College. I then obtained a bachelor's degree from University of Texas in San Antonio in criminal justice with a minor in legal study, and that involves studies in substantive criminal law, constitutional law, legal research, and writing. After that, I obtained my master's degree in justice policy in 2004. After I obtained my master's degree, I was asked to become an adjunct professor at the University of Texas at San Antonio. I taught forensic science, legal issues in forensic science, violent crime, contemporary police practices, and trial and evidence. I began teaching in the San Antonio Police Department in 1988 when I went to the academy, but I've continued teaching throughout my career. I spent 6 years in the training academy before I was promoted to detective investigator, and I was assigned to the homicide unit where I served in the murder unit for at least 10 years, investigating murders and attempted murders, officer-involved shootings, custodial deaths, any type of death investigation was my responsibility. I became the lead instructor for all officer-involved shooting cases. And I actually got promoted to sergeant in 2002. I went back to patrol for a very short period of time, and then I was transferred back to the homicide unit as a sergeant, and I supervised all of those investigations with my detectives and actively participated in those investigations as well. I began teaching use of force in 1992. I went through multiple trainings of practical homicide investigation, constitutional use of force. I went through and became a force science analyst and use of force through the Force Science Institute. And ultimately, I went back to the Force Science Institute and obtained an advanced force science specialist certification in use of force analysis as well. I've continued to teach use of force throughout Texas. I have Texas officers, prosecutors, lawyers from all over the state that come to my courses in use of force and continue to do that to this day. I served as a consultant with the Bexar County District Attorney's Office for 4 years, reviewing officer-involved cases, officer-involved use of force cases, and determining whether or not charges were appropriate or the use of force was appropriate in those particular conditions. And I continue to serve as an analyst with the Kendall County District Attorney's Office in the use of force and officer-involved shootings in my county now.
You're not just an analyst at Kendall County, you have a Your position, not just a consultant, right? You're fully employed by the Kendall County Sheriff's Department.
I am, and I consult on those cases from other jurisdictions that are involved in officer-involved shootings, but I actually handle cases that are involved in my jurisdiction as well.
Okay, and what have you reviewed in preparation for your testimony in this matter?
I reviewed everything that was provided in the discovery materials, including the witness statements, the body-worn cameras, all of the reports that were written in this particular incident, the IDRs, the initial case reports, the audit trail logs, the officer statements themselves, of course, any related report that was provided by the state that was been reviewed and looked at by me. I also reviewed Child Protective Service reports, Child Protective Service reports from Ms. Perez, prior criminal histories as well, prior IDR calls that were made based on Mrs. Perez and the relationship of those particular calls. I've also reviewed use of force, as I do in every day, but I've also reviewed the use of force case law, specifically Graham versus Connor is the main one. I reviewed the San Antonio Police Department's training lesson plan in use of force, which contains, of course, the Graham versus Connor case, as well as TCOL. TCOL puts out a mandatory intermediate use of force course for all police officers, and they actually provide the state-reported or the state-mandated curriculum for that particular course, and that includes as well those use of force cases, as well as many others. And I also reviewed the federal court decision in this case involving the officers here and reviewed that to determine whether or not it agreed with the reasonableness standard as well.
Okay. And do you understand from the court's ruling that you cannot testify about the facts and circumstances of what you read in the federal court ruling as it amounted to this case?
Correct me if I'm wrong, I'm allowed to refer to the fact that I've reviewed cases that are similar to this, that have facts and circumstances similar to this, that have decided that the use of force by these officers was reasonable, but I can't refer to the specific case by name or by court.
I know that's what they asked for, right, in their motion. But did I understand the court in its ruling that he cannot mention the facts of this case in his testimony, Your Honor? The ruling from the magistrate's opinion
I guess I understand, then why would it be relevant? That's the very thing that makes it relevant, is analogous facts and circumstances to inform the expert's opinion as he opines on issues that pertain to the facts and circumstances of this case, which make it relevant under 402 in the charge conduct in the indictment. That is the very thing, well, Butch is saying you're ruling correctly, but that is the very thing that makes it relevant.
You can refer to the facts and circumstances of the federal case without referencing it as the federal case or as a case by Judge Beery or anything related to that.
I want to be clear because he needs to be clear, Your Honor.
Yeah, I won't mention the case name or the judge.
I'm not concerned necessarily about just the case name, but Your Honor, are you giving him authority to talk about there was a case in which 3 officers were accused of shooting a woman in her apartment who charged them with a hammer, the facts of this case, and the ruling was such.
That's a prior case. It is another case. It was in a different jurisdiction. He can refer to that as part of his testimony as an expert in this case. So the short answer is yes.
Okay. So tell me with respect to the cases that you've read that have applied Graham v. Connor that you believe informs the jury or helps the jury in making a decision on this case.
I'm not sure what you're asking, sir. I'm sorry.
Okay. Well,
You want a list of cases? Is that what you're asking?
yeah, I'm asking what do you propose to talk about the facts in particular cases you've read and how the federal courts have ruled on those?
In this particular case, yes, but in the other cases as well. The cases that we're going to be talking about and the cases that I rely on as an expert, given overall legal theory of how the objective reasonableness is supposed to be determined. Graham versus Connor was not a win for the police in that particular case. It was simply a determination of how the courts and how we are supposed to review use of force from a reasonable person's objective standpoint. And all of the cases that we refer to, and I'm sure you know as an expert, I'm not going to rattle cases off the top of my head because we rely on research to do that. But all of the cases that follow that rely on that legal reasoning about what objective reasonableness is and what the standard is to determine whether or not the officer's actions were reasonable under those circumstances. So I will be saying that there are other cases out there that follow the Graham versus Connor decision, and in this particular case, they followed the Graham versus Connor decision in that particular decision that I referenced. They did determine that it was reasonable. They did determine that the officers did not act excessively and their actions were reasonable, as well as that an exigency existed in this particular case.
Are you prepared in discussing about the case, these facts that were discussed in federal court and the ruling was made in federal court, that it only
Sorry.
that it only applied to two of the
Wait, I'm sorry.
individuals? Are you aware of that?
I'm aware that it only applies to two of the individuals. However, what we're looking at here is the reason that it only applies to two individuals is because one of them wasn't included in the suit. He's still charged under the same premises as the other officers were, and that charging relates to his actions and his conduct at that particular scene. And because those actions are interrelated with these defendants, then the ruling about whether or not they used excessive force or was reasonable matches or applies to all three of the defendants, yes.
Well, you would agree that each one's subjective and objective belief is different. It's unique for each person. Would you agree?
No, when we're talking about determining use of force, absolutely. There is a subjective belief of the officers at the scene at that particular time, and that's the reason they did what they did. They had a belief that it was reasonably necessary in their mind to take that action. What we do in the analysis under Graham, and in any analysis that we're looking at whether or not the officers' cases or actions were reasonable, is now we conduct an objective reasonableness determination to find out, given their decision, now let's look at all of the facts and circumstances that existed that made that decision reasonable. And I think that's what the court did in this case.
In the trainings that you give officers across the state for the time that you've done so, do you also incorporate policies that police departments have incorporated for purposes of instructing their law enforcement personnel on how to protect themselves from liability and how to protect themselves from criminal charges?
I do include examples. As a matter of fact, my most recent case, or my most recent class that I taught, I included policies from the San Antonio Police Department and the Kendall County Sheriff's Office as an example of what some policies could look like and what policies may be. Obviously, policy is subjective because it's different for every agency across the state. They're allowed to set their own standards. So that example is used in my classes, but the class itself and the trainings that I teach deal with, this is what the Supreme Court says in determining reasonableness. This is the Texas standard under Chapter 9, and all of that is included in the class material.
And why is that relevant? Your training and how police are trained, how is that relevant to whether or not objectively they had an ordinary and prudent person would have felt a particular way confronted with certain circumstances?
Officers need to know, and they need to be taught, and matter of fact, that's the whole purpose for use of force training that TCOL requires, and any use of force training that a department gives. They need to understand what the standards are, or they need to be taught what the standards are in their use of force, and that it needs to be reasonable. It's a very extreme example, but we don't want to go out and tell officers, here's a gun, go out and use it however you want to. No, these are the conditions in which use of force would be justified, your actions would be justified, and I actually teach that and it is an accepted fact that anytime an officer uses force, anytime any citizen uses force in Texas, by statute, it is an offense. But the officers need to understand that while that is an offense, your actions can be justified under Chapter 9 that will exclude you from any criminal responsibility if these conditions are met. So you need to understand what it takes to be reasonable as well as justified in the actions that you take. And I'm sorry, Ben,
Judge, I believe at this point in time, we're getting beyond the scope of the 705 hearing. I believe this witness has well established his qualifications, and this area of inquiry is beyond the scope of 705 and is actually getting into the area of cross-examination.
I don't believe it has been up to this point, but I am through. I'm after his last answer, comfortable with what we've asked him.
Okay.
Judge, the state of the evidence is very clear. Lieutenant Majeka Butch is highly qualified, and he has sufficient facts and data, reliable principles and methods, and a lifetime of training, longer than my lifetime, to be honest. And he has applied them reliably to the facts and circumstances of this case, and he is entitled to render expert opinions in use of force, reasonable officer standard, and any of the other topics that might come up, with the exception of the policy explanation. Should that come up on cross-examination, obviously we'll have to reapproach on that issue as has become the practice in this court.
Okay.
And Your Honor, one last minor point. I want to make clear that in our joint defense agreement, we, on behalf of Eleazar Alejandro, two of our experts were Lisa and Butch Majeka, but in the interest of economy, we're agreeing to allow Jason Goss and Thomas Nisbet to conduct the directs. I just want to make that clear, and I'm wondering if the court could so inform the jury part of the joint defense agreement.
I'll do it. I'll do it.
Okay.
Yeah.
And Your Honor, as we discussed yesterday, the state would like, and the way this goes, is to do our cross-examination after they've all completed their direct examination.
Okay, we'll do that.
We've not got no objection to him testifying.
it's up to you. I can do it, you can just.
Very good. All rise for the jury.
May be seated.
All right, welcome back, members of the jury. Defense?
Your Honor. We'll do it once. Lieutenant Majeka, could you introduce yourself to the members of the jury?
My name is Thomas Majeka. Thomas is my given name, but since I was about 4 years old, I've been called Butch. So you're probably going to hear me referred to as Butch.
May I call you Butch?
Yes, sir.
Okay. Butch, how are you presently employed?
Currently, I'm the lieutenant of the Criminal Investigation Division of the Kendall County Sheriff's Office.
Okay. How long have you been with Kendall County?
I've been with Kendall County for 13 years.
And could you detail for the members of the jury some of your responsibilities in Kendall County?
My responsibilities in Kendall County to oversee the criminal investigations that are conducted by my office. I still actively investigate criminal investigations myself, but I oversee the investigations conducted by my investigators to make sure that they're thorough, that they're objective, and they're complete, that all of the elements of the offenses are met, and then those cases are filed with the district attorney's office.
When did you begin your career in law enforcement?
In 1977,
Okay. What agency was that?
the San Antonio Police Department.
Could you walk the members of the jury through your service with SAPD, please?
I started in, again, 1977, went through the police academy. When I graduated, I was assigned to patrol, and I served as a patrol officer for 10 years. Half of that time, 5 years, I was a field training officer for new probationary officers that were coming out of the academy. I worked the south side, southeast, and southwest sides of San Antonio on dog watch. Love nights. It's the best shift in the world. But in about 1988, I decided to transfer to the training academy at the police department. When I left and went to the training academy, I became the lead instructor for all the criminal law courses. I specialized in arrest, search, and seizure, code of criminal procedure, some other courses as well, family code, juvenile code. So I taught a lot of the legal courses that were there. I did a number of things while I was there. I was an assistant tactics instructor. You can't tell it now, but I was actually an assistant PT instructor, physical training instructor. I did a lot of different jobs, but primarily my position was teaching the legal courses there. I did that for almost about 6 years, and then I promoted to detective. And was assigned to the homicide unit and was assigned to the murder section. My responsibilities there were to investigate murders, attempted murders, officer-involved incidents, use of force cases, any death investigation that came up, much like Detective Duke that you heard from. We investigated any death investigation that was there, and I did that for 10 years. In 1994, I was assigned to the officer-involved shooting team. We had a small unit of about 6 officers that specialized in officer-involved cases. Eventually, I became the lead investigator for all of the officer-involved shooting cases that happened in San Antonio. In 2002, I promoted to sergeant and went back to patrol for a very brief period of time, about two and a half years, and I was requested to come back to the homicide unit as a supervisor, and I went back again supervising murders and attempted murders, officer-involved shootings, and overseeing all of those investigations and actively participating in those investigations as well. How far do I go?
Are we still at SAPD?
We're still at SAPD. While I was at SAPD, I obtained an associate's degree in criminal justice. I'm going to need it. I then obtained a bachelor's degree in criminal justice with a minor in legal studies. That involved studying substantive criminal law, constitutional law, and legal research and writing, becoming more proficient in the legal aspect of all of the classes and jobs that I was doing. In 2007, I obtained a master's degree in justice policy from the University of Texas at San Antonio, and I was requested, after I graduated and passed my thesis, I was requested to become an adjunct professor at UTSA. I did that for 7 years. I taught Introduction to Forensic Science, legal issues in forensic science, violent crime, contemporary police practices, and trial and evidence. And after about 34 years, I had a family issue that needed to be addressed, and I needed some money to help my family, so that was my decision to retire after 34 years there.
To start collecting on the SAPD pension?
Yes.
Okay. But work didn't stop there.
It did not.
Where'd you go next?
I lasted off for about 2 weeks before I was called by Cliff Herberg, who was then the first assistant district attorney at Bexar County District Attorney's Office, and I was asked to come to work for them. I became an investigator for the district attorney's office here, and I was assigned to the family violence section. My duties were to prepare cases that were indicted and unindicted, violent felony crimes against individuals for prosecution. I did that for 2 years. I was also part of the Capital Crimes Committee with the district attorney's office, and that was their committee that reviewed death penalty cases to determine whether or not a death penalty was an appropriate charge at that time. While I was with the district attorney's office here, I received a call from an old partner of mine that I worked with in San Antonio, who asked if I would come out and head up the criminal investigation division with the Kendall County Sheriff's Office. And because it's the greatest job in the world, I said yes, and decided to go back to investigations, and that's how I began my career with Kendall County. So 47 years in total.
You know how old I am?
42.
Not 47.
I won't say anything. I was doing this job before you even thought of.
Twinkle in my dad's eye. Could you tell the members of the jury if you hold any special certifications?
I do hold special certifications. I have a certification as a medical legal death investigator because of my background in murder investigations and death investigations. I decided to go into that particular specialty, and what that does is it gives us a much greater insight what basically the medical investigators for the medical examiner's office does. It allows us a better understanding of how to investigate death scenes and the evidence and signs of death that we see at these scenes, and understand what's going on and how the body reacts and what happens after death occurs to give us a better understanding of what we're doing. I also went to, there's an agency called the Force Science Institute. They are a nationally recognized agency that deal with use of force investigations. Their focus is on understanding and explaining how things happen with officers, the perception and the attention and the memory issues and the context and the human performance issues of what officers encounter in an officer-involved shooting investigation or a critical incident, officer-involved shooting. And it gives us an understanding of why things happen that help us better investigate these types of offenses to determine whether or not the justification for that use of force existed. I obtained their basic certification in 2004, I believe. And in 2016 was the basic in certification. I went back in 2024 and obtained their advanced certification in force analysis. So that is the highest certification that they offer. And so those are some of the certifications I have.
Thank you, sir. Moving next to what did you review in this case in preparation for today's testimony?
In preparation for today's testimony, I reviewed all of the information that was provided in the discovery packet from the district attorney's office. That included police reports, statements, witness statements, officer-involved statements, body-worn camera, all related documentation from any individuals who wrote reports in this particular case that had something to do with it. I reviewed CPS reports from Ms. Perez, some of the past calls that have been made by made on Ms. Perez. I reviewed every document that basically existed in this particular case. In addition to that, because I was going to be asked to form an opinion on whether or not the officer's use of force was justified in this case, I continue to review the case law that existed on how to form that opinion about whether the officer's actions were reasonable or justified under Texas code as well as the federal standards as well. So I reviewed all of the case law in any cases that involved or similar to this particular case as well.
And for the members of the jury, the statutes, right?
The Chapter 9 statutes in the Penal Code, yes.
The case law, the science behind use of force that you're certified in?
Yes.
These are all topical areas you teach in as well?
Yes, sir. I've been teaching that, as I said, since 1992.
And if members of the jury saw you listening to all the evidence throughout trial and they heard from, say, Detective Platt, you're the individual that teaches those courses?
Yes, sir.
Do you have an opinion on whether Detective Platt paid attention in that course?
Based on her testimony, she didn't incorporate much of what we taught.
Okay, now, all of the reliable principles and methods that you have learned and studied and obtained throughout your entire career, did you apply those in your analysis to the facts and data that you reviewed?
I did.
Okay. And without going into them yet, have you reached expert opinions about the topics we're going to talk about in front of this jury?
Yes, sir.
Okay. In preparing your analysis, did you create anything to help the jury understand some of the significant points throughout the critical incident that you reviewed?
I did.
And what did you create?
I created a PowerPoint presentation from stills from the body-worn camera images that you've seen and you're going to see, as well as an analysis of the content of the conversations and the comments that were made in this incident.
And would utilizing that PowerPoint help explain and put into context your testimony to the members of the jury?
Yes, sir.
Judge, we'd ask as a demonstrative, we'd be entitled to publish his PowerPoint as we walk through his presentation.
Okay.
you want the clicker, or do you want me to work it?
Why don't you work it, because you'll control the questions.
Okay, all right. So, I think the members of the jury have a pretty solid understanding of the call for service and the things that happened on June 23rd, 2023. What I want to focus on is your analysis of significant events in going into a use of force analysis. Is that fair?
Yes, sir.
Okay. So your very first slide here, Robert Ronald's body cam screen grab. Please tell the jury the significance of why you put this slide up here.
I included this slide in there because in the review of the material that I was provided, especially the arrest warrant affidavits and Detective Soto's report, there was a lot made, a lot of comments made or implications made that the window in this particular case was obstructed, that the officers, or she never really had an opportunity to harm the officers because there was an obstructed a television there obstructing that window that prevented her from doing so. I included this photograph to show that she is standing in the window, in between that television and the window itself, and this gives you a pretty good example of there is no obstructive there. And so those comments that the window was obstructed and she could not have harmed the officer, no reasonable officer would believe that she could have harmed them because of that, was inaccurate. The second part of this that I included in here is we're talking about the officer's reasonableness in trying to arrest her without using force. Up to this point, at this particular timestamp on the photograph that you're looking at, up to this point, officers have asked her to come out of her apartment and talk, or come out of the apartment so that they can talk to her at least 7 times. And she has said no on every one of those occasions. In addition, she's mentioned the fact that you need a warrant 5 times up to this particular point. Now, the question about the warrant being included in there and whether or not a warrant was necessary is not really what her intent was. And the reason that I included this was because we can determine, based on what she said, what her intent about mentioning that warrant is. And the content and context of these remarks is clear because, if you'll hit the next area, at 101:45, she makes the comment, "I'm not going to get arrested." You'll hear that on the video. At 102:13, she makes the comment, "I'm not coming out." And then again at 102:15, the reason that I tell you that her mentioning the warrant is in the context of her refusing to be arrested is because she actually says it. At 102:15, she says, "You ain't got no warrant. You can't come in for me." It wasn't a question of whether or not she thought we could go in her house without a warrant or not. She was making the comment that we couldn't go in her house for her to arrest her.
Moving next to a screen grab from Jonathan Salinas' body-worn camera at 1:40:50. What's the significance of this, Butch?
What's missing in some of the, especially in some of the investigative reports by Detective Soto, what's missing in the warrant that was included or that was applied for in this particular incident, is the fact that determining whether or not the officer's use of force is reasonable is also based on the actions of the individual who was resisting that particular arrest and offering force against us. There's no mention in a number of reports about Officer Salinas being assaulted twice before the candle was thrown at him in that particular situation. So I included this in here to show you that. And there was also some mention by the state is it wasn't visible on camera. You didn't see it on camera. Well, looking at the body-worn camera, you can actually look up in this little circled area here, and if you look intently, you can see her hand, okay, coming forward toward, and it is in front of the television. You can actually, if you look real close, you can see 4 fingers of her hand that are in front of that particular television. And this is really all that we can see on the body-worn camera. And there's a reason for that. You know, the body-worn camera records its video at 30 frames per second. But the human eye and the brain process that movement much faster. So we see things happening in a much faster area, but the camera itself makes decisions. The algorithm that's in the camera software actually makes decisions about what frames it's going to include in that 30-second or that 30 frame second. So it will look smooth as it's played to you. You'll actually see it looks smooth playment, but there's a lot of things that are missing because the speed of the camera that it's recording at is not picking this up. You can actually see this in the body-worn camera that you've been provided and that you'll look at. When one of the shots are being fired, you can see fire coming from the barrel of the weapon. But when the other shot is being fired, you don't see any fire coming from the barrel, and that's because the camera is looking for redundant images to eliminate, to get it down to that 30 frame per second category, to keep that size of the video manageable. So we're able to get one frame, realistically, of Melissa Perez with swinging that hammer for the first time at Officer Salinas, and this is all we can see, but we know it happened, not only because other officers saw it, but we do have body-worn image camera that will show that.
Would this be a known limitation on body-worn cameras to experts in the industry?
It is. It's one of the limitations. The other limitation, of course, is distance, which is something Detective Soto testified to. He said when he looked at the body-worn camera, it didn't appear that Melissa Perez was that close. But anybody who understands body-worn cameras and who teaches use of force, because this is one of the things we want people to be aware of and officers to be aware of, is the limitations on body-worn camera with the software, the algorithms, the curved lenses, the quality of the lens that's being used will create distortion. For example, if you were to take your phone out right now and point it at me and take a picture, and then look at me sitting here and then look at that picture on your phone, I'm going to look farther away. So by Detective Soto analyzing that body-worn camera and saying, well, to me it didn't look like she was really that close, you've got to understand that to these individuals who were standing there, that action and that person was so much more closer than it was depicted on the body-worn camera. So that is a limitation that has to be considered in any investigation.
And is there a way during your investigative process to gain more information between those gaps of frames or between those distortions from witnesses at the scene?
Absolutely, and that's really the only way that you're going to get that information, because we know the camera might not capture it all with that understanding that it is recording, but it's not capturing everything. The best way to get that information is from witnesses who are actually standing there and seeing it at a faster speed, because our eyes and our brain function and process that information much more quickly.
Okay, Dan. Can you hold up this with your left hand? Do this with your left hand. Okay. An example being an eyewitness on scene saying she was this close.
Yes, they're much more capable of seeing that than in live testimony than they are in the body-worn camera.
Okay, next slide, 140/50. Again, so we're inside of the same second frame of Jonathan Salinas' body-worn camera. What did you find significant here?
Here, as you said, we're still in that same second of the attack, and you can see her fist is no longer in front of the camera, or in front of the television, and you can see that the arm is beginning to pull back. This is just the beginning of that cocking, and if you'll go to the next slide, you'll see that here now we've got her arm pulling back in this particular fashion. She's preparing again for another swing, simply because we've talked about our Officer Salinas being swung at twice with that hammer, or an aggravated assault on a police officer at least occurring twice. This image shows the preparation for that second swing. Again,
1 second later, what's the significance?
The significance in this video is there are a number of things here that we need to pay attention to. The first thing is, again, that obstructive. The claim by the investigator that this window was obstructed, so it's not reasonable to believe that Melissa Perez could harm an officer. This is the second swing from Officer Salinas' body-worn camera, and if you can see, her arm is outside of that window. The hammer is outside of that window, and respectfully, Mr. Harris made the comment that he thought window screen was knocked out when Officer Salinas pushed it through. We can actually see here that hammer is actually what's causing that window screen to be knocked out. But the point here is her capability of getting outside of this window to strike somebody who is in that vicinity is certainly objectively reasonable.
Moving 2 seconds later to 1:40:53, what was the significance here, Butch?
Here, again, we've had 2 swings, 2 attacks on Officer Salinas already, but in this particular case, it doesn't appear that Melissa Perez is willing to stop the attacks. She's actually backing up. She's pulling back with her arm again and maybe preparing for a 3rd strike, but the only reason to pull back like this is to threaten the officer that he's about to be attacked. And of course, if we look at Chapter 9, when we're talking about the justification to defend ourselves against another's use of unlawful or attempted use of unlawful force, that word attempted use is in there as well. It's not just the actual attacks, but it's the attempted attacks on us that provide that justification as well. So here she's preparing for at least another strike in this particular frame. And if you'll go to the next slide, I'm sorry, up to this point. Now, even during the attacks on Officer Soto, we're still asking her, come outside, please come outside and talk to us. She's now refused that verbally 8 times, and she's now told us 9 times that we need a warrant to come in to arrest her. That was the whole purpose of us, and she has no intent to be arrested. That, I think, is clear from Officer Salinas telling her, you're going to get shot. And her response was, shoot me. I don't care. I mean, she didn't say I don't care, but that's the message that's being sent. Shoot me if you want to. As that's go ahead.
We have some things to talk about on this one. So at 1:40:55, Jonathan Salinas body camera. What was significant to you in this frame?
In this particular frame, again, this is just a few seconds or a second or so after she's cocked that hammer back. And I say that she's intending to swing again because she moves from that position between the window and the TV in the photo. She moves from that position behind that small wall that's right there. And you can actually see her peeking around the corner with that hammer cocked back. And to me, that shows the intent to continue that attack. I'm looking for another target. If you're there, I'm going to hit you. That's the only purpose for moving back and taking that, we'll call it a tactical position, to protect her from the officers getting to her, but also to launch another attack against the officer.
Is it significant at all that she is taking these positions with a firearm being held by a full-duty police officer being pointed in her direction?
It is.
And why?
It's significant because you're talking about an individual who is refusing to come out because she knows she's going to get arrested. Taking these tactical, you know what? I'm old. I forgot you. I forgot where I was going.
That's okay. All right, let's do this. I don't want to miss every flow. Something new, okay? Did you count the number of panels on that wall up to where Melissa Perez's center mass would be?
I did. And yeah. So if you count them from the bottom, 1, 2, 3, 4, 5, 6. 6 would be the exact position of Melissa Perez. You can see that she's bent over just a little bit in this particular photo. But if she was standing up behind this wall, then you would see that center mass for her would be right at number 6. And that'll come in importance a little bit later on in the presentation when you see where some of these gunshots went. But standing up at that area, that is where she's actually trying to hide and not be subject to that any attack by the officers on their part.
Next slide. 141:05, Jonathan Salinas. What do you got for us here, Brent?
This is it's a still shot, but if you were to look at this in a little bit faster, a couple of slides at all, you can actually see this is right after she picks up the candle. Again, her intent is not to go back to jail. Her intent is to attack the officers because she stops attacking with the hammer, goes back and continues to yell at the officers, but then picks up an object for no other reason than to throw it at the officers and try and hit them with it, because we know that's exactly what she does. From this point forward, now she starts to come forward with that particular attack.
Okay. Next frame, 14110 on Jonathan Salinas' body-worn cam.
Here we see her arm cocked, and she's ready to throw that candle out the window. Again, this shows that that window was not obstructed, and her actions in being able to get to a police officer and cause injury if she could, that she's perfectly able to do that. And her arm is cocked back, indicating here comes the next attack on Officer Salinas. Again, by this time, she's now refused to come out 9 times. She's verbally refused to come out 9 times by saying no. And she's also now reminded us that I'm not coming out to get arrested 11 times based on her comments about you need a warrant.
Okay, let's talk a little bit about why this was significant here.
Okay. In this particular case, again, as I put up here, clearly there's no obstruction of the window as Officer Salinas is assaulted with the candle. And looking at the reasonableness standard, okay, and Detective Soto saying that or even the administration or the state saying that no reasonable person would believe that Melissa Perez was capable of harming them because of that obstructed window or because of that wall that was between the officers and the officers on the patio. If you look very closely at this, you can see in the corner where Melissa Perez is, you can see that her entire arm up to her shoulder is outside that window. And just from the position of where her arm is, we're looking at an arm length of about 2 feet, okay? Now add that hammer into that particular arm reach, and her arm reach goes at least, if not farther, to the trim of the door, indicating that window and that wall provide absolutely no protection for an officer who's there. But now we're looking at that 6 feet area of the patio itself. And so we know that she's capable of coming out at least 2 feet without just leaning completely outside the window, which we've seen she's capable of doing. But she's also able to come out that window at least 3 feet or more to where the officers could be standing in front of her or throwing that hammer at the officer standing there. Now take into consideration and remember that patio is only 6 feet wide. Okay, and so from where that rail is to where the officer is standing, unless he's backed up against that particular rail, okay, even with his body width, we're talking at least a foot in front of that rail. So add that foot there and 3 feet to Melissa's reach. We're down to 4. There's only this much distance between Melissa Perez and the officer if they're as back as far as they can be. If that officer was anywhere closer in that 2 foot distance, then obviously we're making contact, or she has the ability to throw, as she did the candle. As you know, Officer Chernak made the comment, is she Ryan Nolan? We've already seen how accurately she can be with that candle. Now she can be just as accurate with this hammer given the time and distance that we have in that particular space.
Next slide, still Salinas, 141-43. Why specifically?
It goes back to, and I don't know if we want to talk about this yet, but it is something that comes into play when we're talking about Melissa Perez's intent and what was going to happen as a result of this particular action. She's here establishing, again, her intent not to come back. As you look at the body-worn camera, okay, and look at the officer's interaction with Melissa, as well as Melissa's interaction with the officers at the times that there's no attacks going on, you'll notice that there's no profanity used by the officers. And I did apologize, I didn't include the profanity in this slide for shock value. I included it for a specific reason, and this is really the only way to show it. I won't use the term, but I want you to be able to see it. Police officers, and matter of fact, anybody will use profanity at certain stressful times to give an intent or a more determination of what it is that you're talking about. It makes you more aggressive. It makes you more positive that this is going to happen. So when the officers tell Melissa, we're going to get you, Melissa, which means we're going to come in and arrest you, her comment is, I don't You can see the comment yourself. And adding that expletive, adding that profanity on there adds an emphasis, and Melissa is actually adding an emphasis to the officers, letting them know, this is my intent, I'm not coming out. She doesn't do it just once. They tell her again, you're going to get tased. And then she replies again, I don't give a, tase me. Okay, so her intent is being emphasized to these officers. I'm not cooperating. I'm not coming out. You're not going to arrest me. There's nothing you can do to change that.
I guess just to put a pin in the PowerPoint for just a moment and sort of transition to, is actively resisting, members of the jury have heard this term, right? Is actively resisting one of the essential elements you consider in what the reasonable officer standard is?
It is. In the cases that we reviewed and the decisions that have come down about use of force, one of the factors that the courts looked at is one of the main three factors they look at is the suspect actively, not only actively resisting, but threatening harm to somebody else or another at that particular time. So those two are in conjunction. But she's certainly actively resisting verbally, but we also see her actively resisting physically as well.
Okay, next slide. We're going to do some measuring tape work on this one. 151-53, this is Maria Salinas body cam. Why is this significant?
This is going to be significant, again, because it goes back to the investigation that was done here and Detective Soto's premise that when I saw what on the video, it didn't look that close to me. But the reality is how close does it have to be? Officer Villalobos' entire upper body is in this window. So we're going to do a measurement here to show you how much that is. But now add on, again, that 3 feet of reach that Melissa Perez had, given her arm and defending her body position, can be even more than that. Add that to the equation and you can see she really doesn't have to be that close, distance-wise, perception-wise, to actually cause injury to the officer.
Do you know how tall Bug is? Bush?
5 foot something.
You'd be happy if you rounded up. Will you gentlemen stand up for me? Judge, can we use the wall for demonstration? Yes. Thank you. You want to step down, Butch?
Sure.
Bring the hammer, please. All right, gentlemen, back up for me. May I have the hammer, Butch? Sure. I'm going to give the hammer to Alejandro, who is about the same height as Melissa Perez was, and I'm going to ask you, Alejandro, to stand over here and just extend the hammer out as if you were swinging it. And Via, I want you to bend at the waist, bend over like you were in the window that night. And then we'll say this close, okay? So I'm going to go from, you want to take the measure tape over there, Butch? I'm going to go from B's butt. Tell me when you're there.
I'm here.
Okay, touch your butt, sorry man, 74 inches. So that's 6 feet and 2 inches of total distance. Is that a significant factor in the visibility of this body camera angle, which we see partially obstructed by the rail?
It is. With him being inside there, she has that 6 feet 2 inches reach to be able to injure him. And how quickly that individual can close that space in that amount of time. We know that we talked about the tool rule, but in about a second and a half, that 21 feet, that second and a half, you can cover about 21 feet. And so how quick, in a second and a half, to get to the back of that, the couch where it was, is about 16 feet. She's there that quickly to be able to, I only need 8 feet to get to where Officer Villalobos is leaning in through the window. I can cover that 8 feet in less than a second.
Okay, next slide. Villalobos body worn camera at 151-52. What's significant here, Butch?
I included this because the significance in determining reasonableness is partially based on what an officer believed at that particular time. And you've heard the testimony that Officer Villalobos reached in and he thought that he unlocked the door. He actually physically did. If you listen to it, you can hear the click in the video of him unlocking the door. And then, of course, Melissa Perez comes at him. So in his mind, he thought he unlocked the door. He actually told other officers that, and everybody there at that particular time believed that the door was unlocked. And again, it's a disingenuous, it's a dishonest statement to put in the affidavit for arrest warrant and the investigative reports that were done, and any report that was done about this, as that she was shot from behind a locked door. That is a factual statement, but that's not the way that the standard is investigated. It's what did the officers believe at that time, and was that belief reasonable under the circumstances? Well, how can it not be reasonable when an officer physically unlocks a door and tells everybody that it's unlocked? So the reasonableness of their actions here based on their attempting to go in is why I included this particular slide. As well as, I think there's some text on this, unless you've got. And again, up to this point, by the time Officer Villalobos tries to go into, I will tell you that I broke this down from the time that the original officers got to the scene and asked her to come out, and she made those comments. But then I broke it down from how many times she made the comments after these officers arrived on the scene. But up to this point, where Officer Villalobos is now entering there, she's been asked to come out 20 times, and she said no. And she's told us that you're not going to arrest me 25 more times because she believes that we needed a warrant. Okay, so we're looking at 45 times up to this point where she has refused to come out and comply.
But you said that we see, and the jury knows this, we see V unlock the door, we see the discussion of that fact be established outside the rail, we see the officers take action based on that reasonable belief the door is unlocked. Here's my question. At the moment that Villalobos has the door handle and then releases it, is there any evidence that he communicates the belief or the new fact that the door is in fact locked?
No, there's not. As a matter of fact, he believed that the door was, and if I understand you correctly, he believed that that door was unlocked all the way through this. When he reached, and actually the attack began, and he reached to unlock the door, again, we're talking about 1 second. And we talked a little bit about human performance issues. What happens to officers that are faced with a very quick and violent attack on them? What happens to the body? What happens to our mind and our perception is our sympathetic nervous system kicks in, and there are a lot of changes that happen in that very short period of time. Your heart rate can go from normal up to 240, 250 beats in less than a second. The body dumps huge amounts of adrenaline that's going to affect how you respond and how you react. And so when he tried to open that door and found that it wouldn't open, and the attack is already beginning, then his ability to, in that particular 1 second, rationally understand why that door would not open, you can make all kind of assumptions. Did I not turn the handle far enough? Is it stuck? We don't know why it didn't open, but that startled and surprised him, and he didn't communicate that in all actuality because he still believed the door was unlocked.
Well, and I guess that's what I want to highlight for the jury is if you were Alejandro or you were Flores, was there any new updating information in that split second that your reasonable belief was now the door is locked?
There was not especially to Alejandro and Flores, because they weren't. I can't say that they weren't paying attention to it, but obviously Alejandro was looking at Melissa Perez because she was coming, and Sergeant Flores, if you look at the video and capture his face on there, you know he's looking at Melissa Perez because she's coming. So they're not reacting to that, and nothing is said. So they don't have any clue that that door is locked and not opening. For some reason, it just didn't work.
Okay, next slide. Villalobos body cam, 151, 59. What do we see here?
I put this slide in here because there's been, again, when we're talking about a reasonable person standard, what would a reasonable person believe under those particular circumstances? And was their reaction justified? I don't want to make light. In looking at this and putting this photo in here, I remembered that as this trial kind of progressed, we've made an issue that Officer Villalobos was a Marine. Okay, and Marines are, they're you know what they are. They're bad guys. I mean, they're good at what they do, and they're supposed to be. They're brave. But the reality is, being a Marine, when you're faced with a deadly threat, this is the same reaction that a Marine would put out as anybody else, as any other person being attacked with deadly threat. It doesn't matter what your position is, it doesn't matter what your training is, it doesn't matter who you are. When you're faced with a deadly threat, you're going to react, especially Officer Villalobos, and how you've been trained. And his response to that fear, to that deadly attack, was to draw his weapon. And it's a reasonable response under these circumstances.
Moving next to 15157 on Maria Salinas body cam.
Maria Salinas, I included this in here as well because we're talking about, again, a reasonable person standard. It's not just Officer Villalobos' opinion that there's a deadly attack coming or an attack that could cause serious bodily injury. It's also the other officers who were at the scene. Maria Salinas is not a Marine, at least not that I know of, but her response, her initial response was, well, wait a minute, I've got to draw to protect Officer Villalobos or to prevent that attack from actually going through. So it is objectively reasonable to believe that anybody who is attacked with a deadly force, even a hammer, a blunt force object, and I can tell you, based on my investigations as a homicide detective, I've handled murders that have been committed with a hammer. I know the damage that can be inflicted. We all assume that damage, but I've seen it. So I tell you that when you're looking at that, was it objectively reasonable for them to believe this? It absolutely was.
Next slide, Villalobos at 15118.
This goes back to not only her refusal to come out, but it also tells you what's going on in her mind through this, to a degree, at least in this particular incident. She's actively listening to the officers outside that are having discussions about what they're going to do or what's going to happen. One of the comments made outside by the officers is, she's ready to fight. And the response to that, if you look at it, is, fight me. I don't, there's her response. I'm listening to what you're doing. I know you're trying to arrest me. I'm not going to let you arrest me. And you know what? If you want to fight, bring it on. And that's what this particular message sends.
Maria Salinas, 15126. What's significant here, Butch?
Again, we're talking about Miss Perez listening to the officers' conversations. What they're talking about at this particular point in this body cam footage is they're talking about beanbags, less lethal means of getting into the house, which, by the way, I'll tell you later if you are now, where do you want?
We're going to go back to beanbags.
Yeah, we're going to go back to beanbags, and I'll tell you why it wasn't an option. But Melissa is listening to the officers' plans on how they're coming to get her. Because if you look at this particular area and listen to it on the body cams, in response to the officers discussing less lethal beanbags, you hear her say, and you actually kind of watch the video to actually hear it, to get the context, but what she does is, shotgun, and like, okay, I'm not worried about it. And it again, established her intent is not to comply and not to come out.
Travis Thompson's body cam at 156 even. What's significant here, Butch?
I put this in here because, again, it shows there's a lot of maybe comments been made about de-escalation and the officers trying to get her to come out peacefully. They were doing, aside from some of the stupid stuff that was done early on in this particular call that these guys had nothing to do with, but now we're trying to peacefully get her to come out of that particular car. You don't want to talk to me? I added this in there because Officer Thompson is now asking her to come outside again in a very calm, very de-escalating kind of way. And again, her response is, and I say that I can tell you why she's not coming out, what's in her mind. What's in her mind is expressed by the voices and the terms that she uses. Nope, she's not coming out because I'm going to get arrested and because I already know how this works.
Moving next to 15906 in Thompson's body cam. What was significant here?
You'll hear Officer Thompson trying to reason with Miss Perez and trying to get her to, and trying to understand, why are we here? Okay, let's calm this down a little bit. You tell me why you're here. Let's try and talk this out so we can resolve this peacefully. So tell me what happened. And again, we go back to Melissa Perez's state of mind. I was talking to the fire department. 2 officers came and disrespect me. They tried to arrest me, and I'm not having that pre-arrest, false arrest, or false accusation again. You know, even though you're rationally trying to speak with her, to get her to come outside and give up peacefully, she knows what's going to happen, and she's not going to have it.
So we move to 156.35, what happens then?
This is just another example of the officers trying to do this peacefully in the wording that they used. And Officer Alejandro, who's at the scene now, who started talking to Ms. Perez. So before this has to get complicated, can you please, I mean, we're asking her, please, can you please just come out so we don't have to use force or anything like that? Again, no, because I already know what's going to happen. Alejandro asked her, what's going to happen? And her response, like previously, I've been arrested for false accusations. I'm not having it anymore. You want me to come out so you can arrest me? And she says, I'm not doing 45 days again for false accusations because I've been there, done that 3 times. I've been arrested. I know what's going to happen. It's not happening this time.
What's the count at now, Butch?
We're at 71 times. 23 times she's verbally told the officers, no, I'm not coming out. And 48 times she's told the officers that they need a warrant to arrest her, to come in and arrest her. So we're talking about 71 times that she's had an opportunity to come out, and she's refused to do that.
And again, this goes back to the significance of the resisting arrest and the level of resisting when it's considered in the objective officer standard.
Yes, sir.
Okay, 20206. What do we see here?
I didn't go too much. You've seen the video of the shooting multiple times. So what I decided to do here was show you that Officer Alejandro had not had his weapon out at this particular time. He's still trying to get her to come out peacefully, even as the officers Sergeant Flores and Officer Villalobos are going over the rail. He hasn't drawn his weapon because Melissa Perez is not armed. She's standing at the television with her hands over the television. We can see that she's not doing anything aggressive at that time. And so he's not being aggressive or taking any aggressive action at all. But when Officer Villalobos and Sergeant Flores go over that rail, okay, this is the point where he sees Melissa coming at the officers, and this is where he now begins to draw his gun in response to that threat that's coming.
Butch, I want to ask you about just a couple seconds before this, because what you said I think is significant. We've heard testimony about they can see the suspect's hands over the TV, and that was significant. We've heard testimony about going against an unarmed suspect is better than going against an armed suspect. But I want to talk about the significance of the pause. When Villalobos first mounts the rail, he pauses, and he's told to pause. Why?
Honestly, I don't know the answer to that.
Okay. At the point at which...
I do know, and I can tell you, that during that pause, and when he did pause, that Sergeant Flores had still notified or still visualized that she was at the television with her hands over the television. And he's now telling Officer Villalobos to go. She's still unarmed. Let's get through the door. Let's get her under control before she can get to that hammer. I don't think the pause was significant in any way except for him going over and Sergeant Flores saying, we're still good because she's still unarmed and she's still right there. And because we think that door is still open, we're going to make it through and get her before she gets that hammer as an attempt to attack us.
Next slide, 20206. This time we're looking at Maria Salinas body-worn cam.
This is from Maria Salinas, and again, it was just an opportunity to show you that Melissa Perez had the opportunity to assault Sergeant Flores. We know because of how far she can get out that window, he's completely vulnerable at this time. Is it reasonable for another officer to believe that his sergeant who's going over the rail and an attack is coming, is it reasonable to believe that that officer believes his sergeant is in danger of either serious bodily injury or death, And looking at his position, Sergeant Flores' position, as we said before, his back is to Melissa Perez. His back is to the door, not because he's done anything tactically inappropriate. It's the only way to get over that rail. Even climbing over the rail, it's really not real easy to keep your head turned around. So you put your trust in the other officers that were there to protect me during that time. And that's what was happening here. Sergeant Flores is exposed, he's vulnerable, and Officer Alejandro sees the attack coming. You can see his arms coming up because he's already got in that shooting position.
Okay. Next slide. Now let's talk about beanbags. This is a little bit blurry, but who is that on the left side of the frame?
On the left side of the frame, that's Sergeant Ed Rivera. He is the individual who had possession of the beanbag. And really, I think when we're talking about reasonableness, I need to point out that it's on the video. You'll be able to see it. You'll have to find it. But on the video, as Sergeant Flores is preparing his plan and getting his plan in motion. Okay, he actually instructs. Sergeant Rivera goes and gets the shotgun, and as he comes back, and before this plan is initiated, Sergeant Flores looks at Sergeant Rivera and asks him, "Can you get her from here? Can you take this shot from the position he's in?" Sergeant Rivera said yes. He's in the position he wants to be, armed with that less lethal shotgun. So he's there and ready to go. That other analysis of what other things could have been done, Sergeant Flores took those precautions and took those into consideration in forming his plan. The reason I included this photograph in here is to give you that perspective of, as Sergeant Flores is going over that rail and where his body is positioned, this is what his body-worn camera sees. Okay, this is what's in front of him. So I'm positioned like this way. Even if I turn my head, and you'll see I put here, even if you add 90 degrees, even if I turn my head maybe a little farther than 90 degrees, I still can't see what Melissa Perez is doing behind me. So I am completely vulnerable from the back and the side. Either way, I decide to turn and look.
Okay. Travis Thompson, a little bit different view here. I like this slide. Travis Thompson's body-worn cam at 2:02:06. What's the significance of this?
The significance of this is what Officer Alejandro saw, or as this was going on, as Sergeant Flores was coming over the rail. This is the attack that Melissa Perez has already begun, even before Sergeant Flores has the capability of getting over that particular rail. So now we know he was even more vulnerable because, again, remember what I said about how close the individual is based on the body-worn camera. She actually appears a little bit closer than this. So she's very close to that window, capable of causing that serious bodily injury to Sergeant Flores had she thrown that hammer through the window. And we don't know whether she was going to throw it. We don't know whether the strike actually stopped it from going through, or whether Officer Alejandro's firing caused her to stop. But we do know that she intended to attack. And that attack actually started because her arm is coming forward and it hits that window, knocking that glass out, that very large pieces of the window towards Sergeant Flores.
So at this point, let's discuss a little bit more about that stress survival response. Okay. The jury scene, Officer Alejandro very intently watching Melissa Perez. A few slides before here, we can see his gun is not drawn. It is still in the holster, but he has his right hand on it.
Yes.
What type of physiological effects is Officer Alejandro undergoing as he sees Melissa Perez get into this striking position so close to the window?
Again, as I mentioned just a little bit earlier, whenever that attack is coming, whenever that amount of stress, that deadly stress or the fear of an attack is coming, the body starts to change. The sympathetic nervous system kicks in, and all of those functions of the body that are not really critical at that time, like digestion and certain other functions that we don't really need, those kind of go into a sleep mode, and we hit what we call a fight or flight status. Okay, either we're going to fight and protect ourselves, or we're going to run, and all of the body's functions start to move towards that to allow us to have the capability to respond in these situations and to become more focused, to become more aware of what's going on based on what we're paying attention to. And there are a number of physiological things that officers that are involved in a shooting will go through. Some of those are called tunnel vision, where you focus on, and that's exactly what this shows. In a tunnel vision situation, you're not aware of anything that's going on around you. We kind of refer to that as inattentional blindness. I know that in this particular case, Sergeant Flores is right here, but I ain't looking at him. And actually, in the time that this is happening, I can't see him because my attention and my focus is narrowed down to where that particular threat is. There's also things called auditory exclusions, where your body shuts down and your hearing, while it may be enhanced just a little bit, you can actually not hear things that are going on. We've handled officer-involved shootings. I've handled officer-involved shootings multiple times where officers can't tell you how many rounds they fired, but their gun is going off 8, 9 times and you're hearing it go off. But your body excludes that information because it's not critical at that particular point for me to be able to count how many rounds I'm firing. There's a number of other effects that affect officers, and I can tell you from personal experience. I was involved in a shooting early on in my career when I came out of the academy, and I actually experienced this. I had that tunnel vision where I fired at a woman who was coming at me with a knife, but directly behind her was an EMS technician who was on scene to kind of prevent what was going on. And there was a house behind her. But the only thing that I saw was that woman coming at me. And the only thing that I saw after I fired the weapon was where the bullet struck. Because that's all your body is capable of, or all you're capable of looking at that particular time. So we see that effect here with Officer Alejandro. This is what he's looking at and this is what he sees. And I don't see anything else, and I may not even hear anything else as a result.
Next slide. Maria Salinas, 20206.
I included this slide because, again, it shows that the glass is breaking. This is a kind of a blurry vision, but there are other slides in here. I think the next one may be a little bit more clear, and you can see the size of this glass that's coming out of that window and hitting, that's possibly hitting Sergeant Flores. Now, there is something that really hasn't been discussed. We talked to you about how the glass can hurt somebody, cut somebody, cause serious bodily injury. But what we really need to kind of focus on to determine whether that's reasonable or not is, it's easy to say, but really when it happens, if I get a cut on me, is that really going to cause serious bodily injury or death? What we don't realize, and what nobody tells us, and unless it becomes a key issue, is there are blood arteries and veins that are in your neck that are very close to the surface. And it only takes 3 millimeters of penetration.
How many?
3 millimeters. That's like very little for one of those major arteries to be cut. And now you're looking at bleeding out within 3 or 4 minutes if you don't get emergency treatment. So these pieces of glass, had they maybe not caused that type of, the minor cuts, it is possible that those large shards of glass, had they come across with enough force, would have caused that 3 millimeters of penetration to get into one of those major veins. That's why we consider this deadly force in this particular concept, and why it's also reasonable to defend against that.
Next slide. Flores body worn camera 20211. What do we see here?
Here we see another, and I have to emphasize here that we're looking at Melissa's intent here. Again, she's not coming out. We've known this. She's told us this at least 71 times up to this point, and now the attacks have begun. So Melissa Perez, after being fired on, after being shot at 5 times and missed by Officer Alejandro, okay, she has backed off to where she is at the couch, and then she stops. And we talk about a pause of Officer Villalobos being on top of that railing. What Melissa Perez does as well is she pauses at this particular place on the couch and then makes the intentional decision, knowing that she's been shot at 5 times, to continue the attack on the officer and start that attack again, knowing that the consequences of what's going to happen occurs. So she chooses to, I've stopped, you shot at me, you missed, I could give up, but no, I'm going to come again, and the attack begins again.
Villalobos body cam 20211. Why is this slide significant?
We're looking at what Sergeant Flores is going to be looking at. He's looking at Melissa Perez in that apartment as she's at the back of that particular couch, okay? And before that second attack begins, that's his line of sight, what he's looking at. And I think maybe the next slide talks about that is it? No,
This was
it'll.
defense 109.
Okay, yeah. So he's looking at where she is, and here, where she is in the apartment. Here we're looking at from Travis Thompson's body-worn camera where Officer Villalobos tries that door. And again, for whatever reason, it's not opening. He can't figure it out. In 1 second, he can't figure it out. So now the events continue on.
Next slide, Flores body cam 20212.
I talked about Melissa Perez standing there at her apartment after she's retreated. She's actually, you can see her standing in a standing position with her arms to her side for a second or so, and then she makes that decision to attack. This is not a moving towards the door, as it says in some of the reports. This is not her rushing towards the door. Actually, Captain Van Geffen, when he reviewed the body-worn cameras of the officer's actions with the Perez family, he actually used the words that are correct. This is Melissa Perez beginning her charge. This is the position that a person takes when they begin their sprint or begin to run, and that's what she continued to do. This was a charge towards the door with bad intent.
This red arrow in the upper left-hand corner, we kind of see it, cutting off part of the door and poking out the light. What is that, Bush?
This up in the top left-hand corner here is actually Officer Villalobos' face. He's leaning into that particular part of Sergeant Flores' body-worn camera. This should give you an indication of actually how close Officer Villalobos was to Sergeant Flores at the time this particular attack occurred. I really can't tell you from this particular perspective whether Officer Villalobos was looking at Melissa Perez or whether he was again looking down, but I can tell you his face is this far from Sergeant Flores when that particular attack begins. And does Sergeant Flores know that?
Okay. Next frame we see, is this another illustrated example of tunnel vision?
It is. This is another example of, Sergeant Flores had that line of sight on her, and as that particular attack begins for the second time, now Sergeant Flores is, and this is probably why he didn't see Officer Villalobos' face in his field of view, or even in his camera's field of view. That tunnel vision restricts not even knowing where Officer Villalobos is at that time, much like I couldn't to tell where the EMS unit was. I'm only seeing where that threat is coming from, and this is tunnel vision.
Next slide, Villalobos body cam 20212, a different angle of that same moment.
Yep. And I will say just briefly, tunnel vision is not a bad thing. Okay, it's not something that is. It's actually something good that allows our mind and attention to focus on that threat. So it's not bad that the officers encounter this. It's actually just a phenomenon that occurs. Here we're looking at, again, I included this particular slide in there to look at Sergeant Flores' response to this particular attack. It was shock, I believe, and you can interpret his eyes, but look how wide his eyes open. He's calling out, yelling, "Hey, hey, hey," or "Stop," whatever his comments are made at this particular point. But this is, again, shock and fear that's being registered by, reasonable shock and fear that's being registered by Sergeant Flores as that second attack begins and as it's almost upon him at that time.
Factors that are significant in measuring a Chapter 9 response.
Absolutely.
Next slide, Flores body-worn camera at 2:02:13, so this is 1 second later.
This 1 second later, you've now got, and remember how quickly you can move in a second. So she's closed that distance in less than a second, that 16 or 14 feet. She's closed that in less than a second. She's right up on the door. And you can see is that in the body-worn camera actually moving, you can see her left arm is out, okay? And in her right arm, she's got that hammer that's now coming back in, not necessarily a tomahawk this way, but it's now coming back for a swing to be come around this way as well. And this is right before Sergeant Flores fires his first shot, as she's ready to attack and she's ready to strike at that particular point.
But circling back to there was no announcement that the door wasn't working discussion. And that's what I've been wondering here. You said her left arm is out like this. Is it a reasonable belief that she would be going for that doorknob?
Absolutely. And again, remember, that door was, everybody believed that door was unlocked, okay? But Melissa Perez may have known that the door was locked. She's the one that locked it. So as she's approaching, if she believes that she needs to come out that door, then at least she's either reaching for the doorknob to come out the door to make the attack, or she's reaching to unlock that door before, so that she can get through it to get where she wants to be.
Television?
Tunnel vision again, but clearly focusing on that hammer is up and raised. And again, remember, body-worn camera distorts the distance, so she's very, very close to that door. So anybody that's close to that door is subject to serious bodily injury or death.
Okay, next slide, 20213.
Sergeant Flores, and we taught you that tunnel vision, okay? And he can see that her arm is up in this particular air at this particular point in time, so he believes that she's going to strike. Would a reasonable person who is about to be attacked with a hammer be justified in using self-defense or using force to defend an individual's oncoming attack of unlawful or attempted use of unlawful force, okay? And you'll see, while that hammer is up, he's firing his first shot. And if you look just right above where her arm is, you can see the indention in the door. I think there's a picture on the next slide that shows where it's gone through. You've seen that. But this is his first shot that's up while her arm is still up in this particular position.
Do you have an expert opinion whether that is immediate or apparent danger of unlawful deadly force?
It is not only apparent, it is immediate danger.
Officer Villalobos, body cam at 20213. What do we see here?
This is a continuation of Sergeant Flores' expression and response to that particular attack that was coming. You've got that wide-eyed stare that he had as Melissa Perez came towards him, and then as she gets closer and as that hammer strike gets closer to the door, now he sees it's a startled response to what's occurring in front of him for that deadly force. And you'll see that, now I gotta shoot. And this is right as his first shot.
You know, Butch, I just noticed something. Will you step down for me, please? Could you show the members of the jury what an officer's trained stance and position would be with a firearm to shoot? I need them to see your feet.
Okay. There are a number of stances that you can be trained with. It really just kind of depends on the officer themselves. But the majority of officers that I've seen in training when we go to qualifications and the training classes that I've been to, this is called an isosceles stance, where you're standing with your feet about shoulder width apart. You're getting a good balance on this. Your arms are locked out in front of you to absorb that recoil and to keep that weapon steady as you fire the gun. There's other stances where you can take this stance, what's called the Weaver stance, which is kind of like a martial arts stance, where you're getting a little bit of balance and control here, and you're still doing the same thing, locking your arms out, absorbing that recoil and making the weapon steady. But you'll see a lot of officers, a majority of officers, you'll see them adopt this stance because it's the most natural, especially when there's some type of a quick or response that needs to be done quickly. It's draw and shoot, and that's what you've seen mostly in all of the videos here.
Just if you stay here for me and entertain me. Looking at Sergeant Flores' back, does it appear pressed up against the wall?
It does. You can actually see as his back curves, you can see the contact of from the middle of his back down to his butt is up against the...
Would any SAPD officer be trained to have their feet in front of their hips and be leaning back against a wall to fire?
No, absolutely not. This is one of these responses, and this is the only option that he had. He has backed himself up as far as he can to avoid that hammer strike and taken as best as he can that tactical position to fire. I'm squatting down, I'm leaning up, but I'm doing this because I got nowhere else to go. That's the only reason that this particular stance is being used here. There's nowhere else for him to go. I mean, could he stand straight up and get off the wall? Yes, but again, we're talking about his movement to avoid that particular attack, as well as I've hit the wall, there's nowhere to go. This is all I got.
Thank you. Okay, next slide. This was a scene photograph. What's the significance here, Butch?
We've seen this photograph, you might recall it from the CSI talking about. This is where Sergeant Flores is rounds hit. And as you look through you have to look very carefully in the body-worn camera. But as I showed you the slide before this, you'll see the very top, which is labeled as B1. That is Sergeant Flores' first round that goes through the door while she has her arm up in this position.
Next slide, Flores body-worn camera 20213.
And this again is just a hammer swing. You can see that hammer is no longer back here. It's starting to come down. You can see the change in the position of the hammer itself. It being pulled back so that as that swing begins, it's in that position.
Over here on the left side of the frame, we see Officer Villalobos. Do you know Officer Villalobos' dominant hand?
He's right-handed.
Okay. Which hand is his taser in there?
His hand is in it's in his left hand at that particular point.
All right. So in order for Officer Villalobos to cycle to his firearm, he's had to take his taser from his dominant to his non-dominant hand.
Yes.
Right. In reacting to the threat of deadly force, would this transfer, does that add to Officer Villalobos' force response time?
It does. It not only adds to the time, it adds to an officer's ability to perform those functions, those kind of, we call them small functions that you have to do with your fingers and your hands. But also, this kind of shows me too, in this particular case, one of the reasons that I included this in here is we talked about the officers wanting to solve this peacefully, wanting to go in with at least the least amount of force possible, knowing that we might have to use tasers. But even after the first shots are fired, even after Officer Villalobos reaches for that door and realizes it's not over, he hasn't made at that point that decision to transfer to his weapon because he thinks that threat is occurring. He's still holding that taser, hoping to go in and accomplish what the plan was until Melissa Perez changed that. And now we're looking at, he has less than 2 seconds to, once this event starts, to transfer. He doesn't even have time to put his taser up. Or you'll see there's a picture in here in the slide that you'll see on the video where he's got the taser and the gun in the same hand at the same time. He's not been able to make that full transition because of the time strength it takes to draw and fire in his mind.
Next slide, 20214, 1 second later.
This is, as you can see, Melissa Perez's arm has come down in that particular attempt to strike. This is Sergeant Flores' second shot, and if you look closely, just below the first shot, there's an indentation in the door. You'll see it in the crime scene photograph next time, but you can see where the second indentation into the door panel is. We know this is Sergeant Flores' second shot, and again, at this point, Officer Villalobos has not had time to transition from his taser to his weapon. That is an ongoing process. You know, there is studies out there and information out there that tells us how long an officer has to have a response time. That's the time that he sees a threat and react to that threat to where the body actually begins a movement. And that's about 0.56 seconds, okay? Before that I realize the threat is coming, I have to draw my weapon. Just the time I have to start moving to do that is the time that's there. Now, I also have to draw my weapon from a level 3 protection holster. That level 3 means there are 3 levels of security on the holster that you have to defeat before you can draw your weapon. And we're looking at about 1.5 to 1.6 seconds for that to happen from a level 3 holster to get on target. So if you're wondering why it took Officer Villalobos 2 seconds to get to that point, he realized the threat was there. He made the determination to fire, take into consideration his response time and the time it takes him to draw, and it matches up accurately from what you're seeing in the video.
And just for the jury's benefit, that level 3 of a holster, that's to protect the gun from falling out, protect people from taking it out unwillingly, things like that.
Yes, there are actually 3 security issues in the holster that prevent it from being taken away from you.
Next slide, scene photo.
B2 is actually the second shot from Sergeant Flores. We've already seen that as it goes through the door and strikes Melissa Perez.
Next slide, Flores body cam 20214.
You've seen, and it's really hard to see because you want to believe that Sergeant Flores' third shot is what knocked all of the glass out of the window. That's not what happened. His third shot actually goes through, and there's a better picture of it in a second here, but it actually goes through right here. You can see the hole that his third shot made. It does shatter the glass because this is that tempered glass that as soon as it hits, it breaks, but it doesn't actually, the glass is actually knocked out by Officer Villalobos trying to get through the door.
So moving to that better frame of the door, there's some other interesting things in this at 202.16 on Flores body cam. What do we see now on the left side of the frame?
What we see now is you've got Officer Villalobos has already drawn his weapon, and as you can see, Melissa Perez is not visible in the door, nor is she visible in the window. And you can see where his weapon is pointed. Melissa Perez is behind this very small wall here, and he knows that that's where she's at. He can't see her, but he knows she's there, and he knows that she's still armed with that hammer.
And then over here on the right side of the frame, Officer or Sergeant Flores is doing what with his left arm?
Honestly, I'm sorry, I can't tell you.
Something like this?
Yeah, I'm sorry. If you look at his uniform, the two stripes that you see there, you can see his sergeant stripes on the top part of the shoulder here. But we also have stripes on our uniform to show the amount of years of service that we have, and that's these two stripes here. And you can see those two stripes are up in front of his head at this particular point.
Okay, the next slide, we're going back in time 7 seconds, 2:02:09 on Nathaniel's body-worn camera. Why was this significant?
Well, you're looking at, again, after Alejandro's first shots, we still has Officer Villalobos with the taser in his hand. His intent is to still go through that door, make it through the door to arrest Melissa Perez as peacefully. I know that peacefully sounds terrible, but that's this, as with using as least amount of force as possible to get her under control. So Officer Villalobos still is here hoping that he can get through that. But what you see is Melissa Perez has retreated back to her couch, and she's bent over the couch. She's not hit at this point, okay, but she's bent over the couch, and that's what I talk about. She bends over, she stands up, she gets herself together again, and now that second attack happens. This is right before that occurs.
We've got a few slides left. The next slide, Villalobos body cam 2:02:15.
Yes, this is a beginning of Officer Villalobos' shots. As you can actually see, as I mentioned before, he still has his taser in his left hand, and now he's got his weapon in his right hand. I haven't had time in that very short period of time to make that complete transaction, but I know there's a threat, and I know that threat is behind this very small section of the wall. That threat is capable of either coming through that door on his right or coming through that window on his left. But I know where she's at, and that threat is ongoing. So I need to stop that threat. You can see his weapon is pointed directly in the middle of this particular wall, about 6 planks up, which is where Melissa Perez's upper body would have been, and his intent was to stop that particular threat as it came through.
So going to that 6 planks up, the next slide, crime scene photo we have in evidence. The significance was the 3-shot pattern on that center wall. Why?
The 3-shot pattern is within that 5 and 6 plank count as you go up. This is where, had Melissa Perez been standing up, then it would have been center mass. Those shots would have hit center mass.
Which states exhibit number 63 included on your final slide. Is that 6 plank where we see those center mass shots?
Yes, you've got 2 in number 6 and 1 in number 5, which would have been center mass.
Okay. Butch, I want to transition a little bit to talk about capturing that eyewitness testimony, right? Taking statements. This is something you teach a course in.
I do.
We heard a little bit from Detective Platt. He said, well, I don't want to ask any questions. I don't want to do any additional investigation. Just put down what you think you need to put down, and that's what we'll do.
Yep.
Do you see any issues in that from an investigative expert's standpoint?
Absolutely.
And what are those issues?
So one of the things that I've always taught, even when I was at the San Antonio Police Department and teaching individuals how to take statements, is taking statements is not just a mere recitation of facts. You don't have somebody sit down and say, tell me what happened, because it's human nature for those individuals to only tell you what they think is important or what they remember after a very traumatic event. memory is really funny. You can remember some things, you can remember not some things. All those hot spots stay in your mind. I very clearly remember what happened to me in my very first shooting, because those hot spots, I don't remember all of it, but I remember the hot spots that I can tell you about because those are in my brain. But in taking a statement, one of the things that you don't do is tell me what happens. And when I was a sergeant with the police department, and even now in my agency, I refuse to allow my detectives, and refuse then to allow my detectives to use what we called handwritten statements. And that process was basically what the detectives are doing today, is handing a witness or handing a victim or handing an officer a statement and says, write down what you remember, or write down what happened. I could give you an example of, I did that on one shooting, or it was done on one shooting. I used the example in my class where the response came back, saw the shooting, that's all. Okay, that's what happened in a handwritten statement, because that's all the person thought he wanted to talk about. But in taking statements from officer-involved shootings, one of the purposes, as you've heard from Sergeant Miller, one of the purposes of an investigation is to determine the truth. And in my classes and in my teaching and in taking statements, you have to ask questions. If you don't tell me something, it's not on you. It's my responsibility as an investigator. I'm tasked with the task of determining whether or not this officer was justified, whether there were any defenses, whether there are affirmative defenses, if there's any reason that criminal charges shouldn't be filed in this particular case. That's on me to find out. And I can't find that out if I don't ask questions. I remember during testimony, a statement was made, Sergeant Flores didn't tell you anything about, now I drew another blank.
Bedridden old man.
He didn't tell you anything about the bedridden old man. He didn't tell you anything about this over here. And the response was, no, he didn't. No, he didn't. It's not Sergeant Flores' responsibility to, first off, it's not physically possible to remember every single thing that happens in a particular situation, especially a traumatic situation. There's actually courses that are taught out there that teach how to get that information from individuals who are witnesses or who've been involved in a traumatic event. One of them is a cognitive interview process, where you ask them what happened, and then you go back and you ask questions to clarify, and then you go back and have them tell you what happened from backwards to forwards. All of that stimulates the brain to recall certain events, and you're looking for specific information to address questions. Why? Why did you fire at this particular point, officer? Okay? The answer you're going to get from most police officers is, I was in fear for my life. Okay? A legitimate reason to fire. But when we're trying to determine whether justification exists, the next question should be, why were you in fear? What factors did you see? What was occurring at that point that caused you to be in fear for your life, to justify that statement? And that process has to be done throughout the taking of the statement. You can't just sit there and say, tell me what you want. It's my job to find that out, to draw it out, because that's the purpose of that particular investigation. And that was not done here in any way, shape, or form.
All right, let's go ahead and take a short break. All right, retreat.
be seated.
All right, welcome back, members of the jury. Defense?
Thank you, Judge. Butch, just as a matter of housekeeping, which of these lawyer teams had initially approached and retained you to consult on this case?
Mr. Cifuentes did.
Mr. Cifuentes,
Yes.
And then, before you testify today, just for sort of a logistical reason for the members of the jury, I'm the one questioning you first.
Yes, sir.
Okay. But when you were brought on initially and retained, consulted to discover the truth in this case, it was on behalf of Officer Alejandro and his attorney, Benson.
Yes, I've been working with Mr. Cifuentes primarily.
Thank you. Okay. Turning our attention back to your investigation, Butch, do you have an expert opinion on the quality of Detective Soto's investigation in this case?
I do.
And what is that opinion?
This investigation by Detective Soto was flawed at best. I believe you heard Sergeant Miller talk about that. But it was also incomplete because there really wasn't an investigation. There was, and what I teach my investigators that they're not just secretaries. They're not to go out and just collect information and cut and paste all of that information into a report and then pass that off as some investigation where you've sought the truth. Looking at this investigation, that's probably exactly what happened. The majority of his 60 some odd page report was a cut and paste of everything that had been collected by somebody else, but there was no analysis. There was no, and even looking at the analysis that was done in that cut and paste, when I say analysis, even at looking what he did in that cut and paste, he never went back and corrected those misleading misstatements of what happened in this investigation that led to justification, but he never went back and sought out any clarification of what had happened or what these individuals said or what the evidence meant or what the body-worn camera looked like. You cannot, in looking at this particular case, and I know it's impossible for you all to watch 16 hours of video, but for us as the investigator to be able to look at that video completely, not maybe frame by frame in the ones that you want to look to, but minute by minute in that video, there is always something in that video that could lead to information that you don't had. I had an investigation where I was doing a sexual assault of a child, and we had obtained hours of video that the individuals had taken of themselves having sexual intercourse, and none of the detectives wanted to look at that. But going back, and I decided, okay, I'll bite the bullet. I went back and watched all of that video, and interspersed in that video was the individual and the subject he was having sex with admitting to sexually assaulting their own children. Okay, and that would have been completely missed if that video hadn't been watched. So you have to look at everything that you have, and when then that raises questions, you have to go back and clarify that information and at least be objective about it. And that's the biggest thing about this investigation that flawed, is there is no objectivity in it whatsoever. There was a decision that was made. There was a choice that was made to charge these officers, and everything in that investigation was geared toward proving that they did something wrong, including the misleading statements of fact that are in there to support that confirmation bias. This investigation would have never got out of my office.
Moving next to the objective reasonableness standard that is pronounced. That is the standard for officers in conduct in deadly force shootings.
Yes.
Do you have an expert opinion of Officer Alejandro's conduct on the night in question as it pertains to the objectively reasonable officer standard in a deadly force encounter?
I can tell you with legal certainty that Officer Alejandro acted reasonably in that situation in defending Sergeant Flores and Nathaniel Villalobos. It was immediately necessary for him to take action, and that action was reasonable.
Same question. Do you have an opinion on behalf of Nate, on behalf of Officer Villalobos?
I do.
Did his conduct, or how did his conduct, if at all, comply with the reasonable officer standard as is applied through principles and tactics, and principles, what are my terms here? accepted and codified law enforcement standards. There's the phrase.
In this particular case, Officer Villalobos acted reasonably based on all of the information that was available under the circumstances to judge his particular conduct for justification. He believed that his life was in danger. He acted reasonably, he acted appropriately, and under Chapter 9, he immediately thought it was reasonably necessary to use that force to defend himself from an oncoming deadly conduct attack.
Same question. Sergeant Flores.
Sergeant Flores as well. My opinion, he acted reasonably under the standards of objective reasonableness in this case. Was it objectively reasonable for him to believe, or any other reasonable person in his place, would you believe that you would have reacted the same way based on the deadly force conduct that was coming towards you? And my expert opinion is, after reviewing all of the facts and all of the cases involved in this case, I can say with legal certainty that he acted appropriately and reasonably when it was immediately necessary to use deadly force to defend himself.
Thank you, Butch. Pass it with the judge. It's up there.
May I proceed, Judge?
Yes.
Lieutenant, I don't call you Lieutenant, do I?
No, sir.
Do I have permission to call you Butch? I don't want to disrespect your training and your experience and your title, but do I have permission to call you Butch?
Yes, sir. I don't stand for morality.
Okay, so Butch, is that your legal name, by the way? I've always known that.
My legal name, no.
What is
My legal name is Thomas.
I see where you get Butch from.
Yeah.
Okay. So Butch, this is supposed to be cross, so I'm supposed to be leading you. It's going to be kind of a conversation, okay? If I can talk fast, and I'm going to try not to. So if I talk too fast, or if I ask a question that doesn't make sense, just say, Nico, ask it again, or clarify what you think I'm asking, and I'll let you know if that's what I'm asking, okay?
Yes, sir.
So I'm going to kind of get you leading, and then also open up your questions, because this is not a normal trial setting.
Yes, sir.
Okay. So you use terms, you caught my attention. You use terms like we could go in if needed, and us, and our. Now, is it fair to say that you're looking at this because you're a law enforcement?
Yes,
For
sir.
7 years. Can't.
Active duty law enforcement.
Right. And but what I want to ask there is there a bias? Do you have a bias towards helping these three officers?
Oh, I do not. Absolutely not.
And I want to talk about that, because have you been involved in investigating law enforcement officers for prosecution?
Sadly, I have. Yes, sir.
And you say sadly because you love your profession.
Yeah, absolutely.
So for me, when I was a prosecutor, as a defense attorney, if a lawyer gets in trouble, I would say the same thing, because I love my profession and I don't want anybody else to give it a stain. Is that what you mean by that?
Yes, sir.
And so you have actually arrested law enforcement officers before, haven't you?
I have.
And you've testified on a stand like that for a table like this, meaning for the prosecution to ask a jury to convict a law enforcement officer before.
That was my career. Yes, sir.
And so, is it fair to say that when Mr. Cifuentes first spoke with you, he was asking you for your expert opinion to evaluate this situation?
Yes, sir.
And isn't that how either the government or defense, and this is only the second time you've ever testified for the defense, right?
Just the second time. Yes, sir.
In 47 years?
Yes, sir.
Okay. So they hand you, and you've heard the term of a consulting expert.
Yes, sir.
You know the difference between a consulting versus a testifying expert?
Not really.
Well, let me just ask you this. Would you know that you can consult but not testify?
Oh, yeah, absolutely.
That's
Yes,
what I
sir.
mean. And then sometimes you consult and testify.
Yes.
Would you agree that Mr. Cifuentes asked you to consult first because he had no idea what your opinion was going to be?
That's true.
And when you got the evidence that the government gave us, you had no idea what your opinion was going to be either, right?
I didn't.
Okay. But then at some point, you came to the conclusion that you felt ethically and legally comfortable, and I know you, so I'm going to say morally comfortable, to stand under a sworn chair to tell people in our community your position on this case.
Yes, sir.
Okay. So I want to talk to you a little bit about concealment versus cover, because Jason always hits on me because he uses the word cover, and I get all bananas because there's a difference between concealment and cover. Would you agree?
There is.
Okay. May I approach, Judge?
Yes.
We use terms, and we can't assume that juries speak our crazy world, right? So, sorry, Mr. So, can you see me?
I can't.
Am I covered from any attack, whether a hammer, a knife, or a gun?
You're concealed, but I can still
I'm
attack you.
concealed, not covered, right?
That's right. You can still attack.
So for the jury's perspective, cover means that if you're shooting at me or attacking me, then I'm safe.
That's right.
Concealment just means tactically you can't see me exactly where I'm at, and I can come from a low position out, or I can come out from this side or from this side. So it distorts your attack on me, but it doesn't mean I'm safe.
That is correct.
So I bring that up because I want to talk about this wall that the government has made an issue of. And I want to make sure that the jury has the information they need to make the right decision, okay?
Yes, sir.
So we're going to get to that because would you agree that in your experience of training officers, evaluating cases, and teaching, that you could see a situation in a scenario where tactically it made sense and was absolutely reasonable to shoot through concealment?
Absolutely.
Have you seen situations where officers actually shoot through cars?
Yes.
Would you agree that cars, unless you're at the engine block or the corner, is not covered?
Correct.
I'm not going to get on the ground right now in the suit, but you can get on the ground and there's the tire and the wheels and the frame of the car. So tactically, you can get on the ground and have a little bit of cover, but it's usually just concealment.
Yes, you can fire through the doors, you can fire through the windshield, you can fire through, except, as you said, the engine block will provide you the greatest protection, but for the most part, it's concealment.
It's concealment, and only the engine block and maybe one of the areas is covered.
Yes.
Maybe like a frame. Okay, so I'm gonna say that because we're gonna get back to that because I want to talk about Officer Villalobos shooting through that wall in that circumstance at that time, because I'm trying not to go over what other people went over with you, but if I need to clear something up, you kind of direct me to, okay, Butch?
Okay.
So if Melissa Perez, after the charge that we saw this double attack, right? May I push, Judge?
Yes.
And I want to make sure that I understood what you were saying, but I never take this for granted. I'm sorry, sir. This way. Would you agree that under the circumstances, that Nathan Villalobos, probably and Officer Alejandro, didn't know for sure if Melissa Perez had been struck?
That's true.
And so, because Officer Villalobos, when we look at the camera, we look at the video, she was fired on multiple times by Officer Alejandro initially, and she was not struck. She went back to regain her footing, and then, as you testified earlier, she came forward and attacked again.
Yes. By all accounts, you can see that there was actually no communication that she was struck until after Officer Villalobos fired his rounds. Until then, they believed that she was still up and moving around and behind that wall.
Yeah, and I'm gonna get there in a second, but thank you for that. So if she had not been struck, and I think Jason asked somebody about this, but if she hadn't been struck, and knowing she had a hammer and how she used it, and would Melissa Perez still be a threat?
Yes.
Now we're going to talk about this in a second. We saw those pictures. Can we get the cattle picture up? Okay, if you can. Coming around, she can come around this way. And I think you showed that, and you spoke to Tom. I'm not going to call him Mr. in this, but to Tom about that when
Yes.
you reached out of the video. I mean, out of the frame, correct?
Yes, sir.
And at that point, regardless of whether she could hit or not, it was reasonable to think that she could strike, either release the hammer or strike either Villalobos, Nathan, or Sergeant Flores, correct?
Absolutely.
Now, when you talked about it a little bit, but the second attack had a very different stride. Would you agree?
Yes.
And also a different swing.
Yes.
The first swing was this way, correct?
Yes.
But looking at the position, and I'm not trying to be insensitive. Okay, their families. I'm not trying to be insensitive, but the second time, would you agree with me that it appears, and I believe other people will testify to this, that she was making a beeline and meaning a direct charge for that door?
Absolutely.
And would that make sense as an expert and someone expert in tactics and use of force? Huh? Oh, that's it right there. That's it. That's the example that I was using earlier, right? So this, if Nathan was there, or if Alfred Sergeant Flores was there, this, or if I'm not gonna even pretend to do that, if she would have let go of it, obviously could have caused some damage as well.
Yes.
Okay. But coming this way, does it make sense? In where her body unfortunately laid, and where she was going, and if somebody had done a Leica scanner, and we're gonna hear from that shortly, I'm sure, that it makes sense that she's coming this way to come out the door and to strike this way.
That's absolutely possible, yes, sir.
And so you open the door, and it would be a different strike, because it wouldn't be as effective if you open the door and then try to come out this way with it, correct?
Yes, correct.
So this position tells someone with your experience something, that first attack was at the window, second attack is to this door.
Yes.
Now this is where I want to get into apparent versus actual danger. Because the jury's heard a lot about this door being locked, but everyone at the scene thinking it was unlocked, right?
Yes, sir.
And we're not going to watch it again, but we saw Officer Villalobos' body cam where he reaches in, and you can see that he has a view of the apartment.
Yes.
He knows what's out. He knows what's behind that concealment.
Yes, sir.
And if we look at the 4 gun safety rules, right, we know you don't point a weapon at anyone you're not prepared to kill or destroy. You always keep your finger high and outside the trigger guard until you're prepared to discharge it, correct?
Yes, sir.
What's the next one? You always treat it like it's loaded.
Yes.
And you know what's behind your target.
And make sure your target be on, yes, sir.
And, so there, thank you. And so this is the view. So we know that Officer Villalobos has reached in, but you made a statement earlier. Just because that's what the body cam shows, I mean, it doesn't show what the eyeballs are looking at. So it's a different view as he's looking in. He scouted the room. The body cam is picking up his torso, but it doesn't mean that his neck is not scanning the room, correct?
That's correct.
And that's for anybody's body cam.
Yes.
And is that the distinction that I think Jason was making with Detective Soto? Detective Soto was so focused on the body cam view, but an experienced detective like yourself and Lisa Miller and Sergeant Miller knows that the body cam doesn't pick up everything, because number one, there's a difference in height, but also there's a swivel.
Yeah, there's absolutely a swivel, and that's one of the main reasons that we talk about obtaining statements from individuals, to ask those questions. Why? What were you looking at? What did you see? Why did you do this? And which obviously we know wasn't done here.
And we're going to talk about what Detective Soto did or didn't do on that in that part of his investigation just briefly. But even we know that the door was factually locked, but apparently it wasn't. And you've heard about apparent danger.
I teach the topic, yes, sir.
Then I guess you've heard about it. So then when we talk about apparent danger, and most courts, and we have every reason to believe this court will instruct the jury on apparent danger, and just in rough terms, apparent danger means that you treat that apparent danger as if it's actual and you can respond appropriately.
Yes.
I'll give an example. I was going to do this later, but since we're talking about it now, I want to keep it in context for the jury. I'm going to give you a scenario. You and I are in a coffee shop, right?
Yes, sir.
And someone walks into that coffee shop with a black trench coat in. May I stand up, Judge?
Yes.
And yells, "Everyone in this coffee shop deserves to effing die," and reaches back behind this black trench coat with black t-shirt, black pants, boots, and everything like that, and sunglasses. Now, in today's world, we have to look at whether it was reasonable, whether it was apparent, and whether it was imminent, right?
Yes.
Under Chapter 931, 932, and 933 of the Penal Code.
Yes.
The law says that you and I don't have to sit there and go, "Hey, Nico, hey, Butch, do you think he's got a real gun in there? I don't know. I wonder what he means by we should all effing die. I don't know, let's wait and see." Because if we respond and we draw weapons and shoot, and later they find out that he had a journal behind his back with all the reasons why people in that coffee shop should effing die, that doesn't mean that you and I are guilty of murder.
It does not.
And so we would have to look at reasonable. In today's world, I'm 53 years old, so you haven't been working as old as I am, maybe Tom, but in my time, I mean 25 years ago, it was unheard of that people were going to walk into movie theaters and shoot up people, right?
Yes.
Churches, it was unheard of.
Yes.
Malls, it was unheard of.
Yes, sir.
Yoga studios, it was unheard of.
Yes, sir.
Now nothing's off limits. Is that a fair statement?
Nothing.
Okay, so the law, responsible prosecutors would look at whether that was reasonable for us in those circumstances to think that that person was intending to cause a serious bodily injury or death.
Yes.
Right? And if we didn't act, whether it was imminent, meaning immediate, if that was a real gun, somebody was going to get hurt or killed.
Yes.
And even though there was a journal, under those circumstances, reasonable prosecutors and investigators and detectives could say, under that set of circumstances, that was reasonable.
Yes, as a matter of fact, when we're looking at my job as an investigator and looking at those statutes, the statute actually reads that based on whether it's perceived in my eyes, not the public's eyes or anything else, but how I perceive that particular incident to be. If that's what I believe, then it would be reasonable.
And if it's reasonable.
And if it's reasonable,
Because
yes.
what the statute tells every...
Your Honor, I have to object. It's an improper statement of reasonable belief in the statute. The statute calls for an ordinary and prudent person standing in the shoes of the officer, not the officer's subjective belief.
You can bring that up in cross, but that's fine. We'll take that definition. So an ordinary prudent person, if a reasonable prosecutor determined that you and I were ordinary and prudent under those circumstances with that set of facts, with that immediacy, and with his language and body language and what he was wearing, then that would not necessarily mean we were guilty of murder.
That's correct.
Can we change the scenario?
Yes, sir.
Same scenario, we're in that same coffee shop, but this time that same guy walks in butt naked. Changes the reasonableness, would you agree?
Yes, it does.
Because, may I stand up, Judge?
Yes.
Because even though he says everyone in this coffee shop deserves to F and die and reaches back, I don't know where he's reaching, but it's not the same threat,
That's correct.
right? I can have my imagination to go wild, but you understand my point.
Yes,
So if you and I shot at that moment, it would not be reasonable.
that's correct.
Now, if he still walked in butt naked, but had a knife in his hand, the threat is still real.
Yes,
I mean,
it is.
a legit knife. And if there's a gentleman sitting here in the coffee shop, now 933 steps in on defense of third person.
Yes,
And what the statute says is you and I, sitting where you're at our coffee shop, can place ourselves in the position of this patron right here and act as if we were defending our sergeant.
That's correct.
Defending ourselves, correct?
yes, sir.
And so that applies to this situation with Officer Alejandro as well,
Yes,
and Officer Villalobos,
yes, sir.
and Officer Flores, Sergeant Flores.
Yes,
I can't say exactly what Detective Soto would say, but if a detective said, but it wasn't reasonable in my scenario, because it was a journal, not a gun, that would be a misapplication of apparent danger under the statute.
it absolutely would. The statute, when we talk about apparent danger, continues on and says it's whether or not they believe that danger is real, even if they are factually wrong, the apparent fear still takes place and controls.
Yeah, like a locked door.
Yes,
And so when it comes to self-defense, defense of third person, use of deadly force, would you agree with this statement? It's very fact-driven for that scenario,
yes,
because every scenario is different.
that's correct.
I mean, just in our scenario, I gave you 3 scenarios that changed up whether you and I get in trouble and accused of murder or not.
Yes, sir.
And it matters how close, may I stand up, Judge?
Yes.
On the naked guy with the knife, it matters how close Ben is in our third scenario.
That's actually correct.
I
Yes,
mean, if I walk into that same coffee shop naked with a knife and Ben is over there, now we're thinking of that Tula rule that we'll talk about in a second, right?
yes,
And then there's a forced science sprint study that you and I are going to talk about. Would you agree with that?
yes,
Okay, but that changes the reasonableness because we're looking at very fact-specific evaluation.
yes,
Now, even though, let's say that, I'm going to give you another hypothetical as an expert. Let's say that an individual knew a door was locked. Like in this case, let's say that it was known that Melissa Perez's porch door was locked.
yes.
Who controls the lock of that door?
Melissa Perez does.
So she wasn't locked in, the officers were locked out. Is that a fair statement?
Yes, it is.
And the person that is locking the other people out, they have control of that lock.
Yes,
Knowing a door similar like that in an apartment, would you agree that this wasn't Fort Knox? I mean, it wasn't a bolt in an old school castle. I mean, it was literally just a turn.
yes,
But it was a turn that, thank you. It was a turn that Officer Villalobos didn't realize it was an extra step that had to be done.
correct.
And we're going to talk about what they did when we get into the chapter 32 and chapter 933 in a second. But my point being is that door was controlled from the inside, not from the outside.
That's correct.
And we know that, just to be crystal clear, because Officer Villalobos, Nathan had to reach in the inside to apparently unlock it.
Yes.
And he did unlock it factually, right?
Factually, he did, yes.
He just didn't unlock it completely, but he didn't know.
That's correct.
And we'll talk about how we know that objectively. So I want to draw your attention now to Detective Soto's investigation. I'm really not trying to dump on this guy, but if it wasn't such a serious situation, I'd probably feel worse about it, okay?
Okay.
But I don't, because if we're going to talk about these things, and I know that Sergeant Melissa talked about it, but I'm going to talk about it as well. You would agree that that was a horrible investigation.
Yes.
I'm just going to say what it is, and maybe that's not your word, so use the word you want to use.
I'll use the word horrible.
Okay. And it's not horrible because he ended up walking warrants on 3 officers without doing it. It's a horrible investigation because of what you heard when you sat there listening to cross-examination.
Yes.
Because his investigation was being tested.
Yes.
And when you do an investigation, any detective knows that you're going to come into a court of law, you're going to look at people in this community, and you're going to ask them to convict somebody. And when you're testifying, it's to convict somebody for murder.
Correct.
And there's consequences to that.
There definitely are.
And so when you come into a court like this in Bexar County, you know you're going to be tested.
Yes.
And he was tested.
Yes, he was.
And there was a lot of things we saw went wrong in that investigation. Would you agree?
Absolutely.
So he said something that caught my attention, but I want to ask it to you, Raw, and you tell me what you think about it. He said, I walked a warrant, and here's the word that I wrote down, as soon as I had PC.
Yes,
now,
he did.
PC is probable cause.
Yes.
Probable cause is the minimal standard that any officer or detective needs to accuse any citizen in Bexar County, and potentially they'll be facing prison time, correct?
Yes.
Okay, unless it's a misdemeanor. And so he said, I walked as soon as I had PC. Is it a detective responsibility to make sure they have PC?
It is.
Now, let me ask you this. Is that their goal? Is their goal to have PC, or is their goal is to find the truth of what happened in a situation?
No, our goal is not to determine PC. As a matter of fact, he knew he had probable cause the minute the shooting happened, simply because of the fact that we use force, and the statute says we can't unless there's some justification for it. So he had probable cause immediately. He just misunderstood his purpose in this particular investigation. His investigation was to find the truth, to determine whether or not that use of force was justified, and that's where he failed.
So you,
Yes.
so you said something there. So he knew he had PC. Thank you. He knew he had PC as soon as he realized that the officers discharged their weapon and they were hit. Melissa Perez.
He should have known that, yes, sir.
Okay. And just like any detective would have PC, every time an officer draws their weapon, and if they don't discharge it, but they point it at a citizen saying, I said get down, let me see your hands, let me see your hands. What is that offense typically? I'm sorry, David.
Typically, it's deadly conduct, or depending on where you're pointing it, it could be aggravated assault.
Exactly. So every time an officer draws their weapon, we watch I don't watch it, but some people watch cops. So anytime an officer draws the weapon in any show, or any real life show, or in any situation we read in the news, that is either deadly conduct or aggravated assault with a deadly weapon.
Under Texas statutes, yes.
Unless there's a justification.
Yes.
Right? And so for Detective Soto said, and for the government to say, well, you had PC, so you had a duty. I mean, anytime you know that an officer drew a weapon or discharged that weapon, you at least have deadly conduct, aggravated assault, deadly weapon, or unfortunately murder.
Yes.
Now it's only whether we apply the statute and the facts meet the statute to say there's a justification for that.
That's absolutely correct.
So the fact that Detective Soto said, as soon as I had PC, did that cue you to maybe there was some other motivation to his investigation?
Yes.
And we'll talk about what that is in a second, because we've heard some about that. Jason talked about, and I think I brought it up with Detective Platt a little bit, I don't remember, but we called them these 3 scenes to this whole incident. Do you remember hearing that?
Yes, sir.
And God bless you. We call the first scene, Rojas Ramos, right?
Yes.
And we know that they did not do a very good job in law enforcement during scene 1.
Yes, not at all.
Their lack of doing and following their training, should that be imputed on these 3 gentlemen?
No, sir. They didn't know what happened.
And would a responsible detective do that?
Yes. Well, the responsible detective wouldn't have held it against him. They'd have determined that it didn't have anything to do with it.
And you kind of shave that portion off, right?
Yes.
But matter of fact, the responsibility was from Rojas and Ramos to them, not the other way around, because they had no idea what they were walking into.
That's correct.
So we have a situation where Rojas, and I'm only talking about it because it came up initially, Rojas failed to apprehend Melissa Perez.
Yes.
And we're going to talk about emergency detentions briefly because I fear that there's been a misunderstanding or misperception to the jury. So what is needed for an emergency detention before you do it?
In order to emergency detain somebody and take them in for evaluation, it says that we can take a person into custody without a warrant if we have reason to believe. And that reasonable belief doesn't necessarily equate to probable cause. It just means we've got something close to it. But we've got real good reason to believe that this person is experienced some type of mental crisis or mental degradation. And in addition to that, there's an and. It's not just the fact that they're having a mental issue. There's a number of people who have mental issues that are not problematic. But it requires that they not only have that mental issue, but they have to be a danger to themselves or other. That danger is actually the critical part of it. Without that danger to themselves or other, then we can't take them into custody. It's mandatory and required by law because the statute says and is a danger to themselves or other.
But even though, because we used the word, we heard the word emergency detention thrown around here flippantly, but you still have to take someone into custody.
Yes, absolutely.
So even if Rojas or Ramos or anybody, and even if the three officers behind me knew, although they didn't, she was going to have to be apprehended.
Yes.
It's not like people volunteer to be emergency detained. You have to put them in custody. Is it a fair statement?
People voluntarily submit to evaluations, but they don't voluntarily submit to be taken against their will. That's what the emergency detention for is. We're taking them against their will because they present a danger.
And then when somebody is going against their will, there's oftentimes some type of force have to be used against that.
Absolutely. That's the majority of those situations, yes, sir.
Okay, but all that being said, that was scene one, and so would you agree that neither a prosecutor, a detective, nor a jury should hold scene one, Rojas and Ramos, against Sergeant Flores, Officer Alejandro, or Officer Villalobos?
They should not.
Okay.
They didn't know.
Scene two is Officer Salinas. Remember that?
Yes, sir.
So he shows up, he makes the decision, he asks permission, he makes the suggestion to go in through the window. We can argue all day long of whether it was legit or not. I know what your opinion is, he had reason to go into that window, correct?
Yes.
Okay, and legal minds can disagree, but regardless, at that point, and we've seen the video way too many times to show it again, she charges, they're not there, and she swings. May I stand up, Judge?
Yes.
She swings at Officer Salinas, and as I think Tom went over with you, the hammer goes exactly where Salinas was.
Yes.
If she had fulfilled her objective of smashing Salinas in the head with that hammer, could that have caused serious bodily injury or death?
Absolutely.
If Officer Salinas, and thank God he did not, if Officer Salinas would have passed away because Miss Perez would have accomplished her goal, what would you have hoped this table would prosecute her for?
She would have been charged with capital murder.
Capital murder. What would she be facing if she was charged with capital murder?
Life without parole or death.
Okay, and that's the most serious offense, right?
Yes.
So if she accomplished her goal before they got there, and then unfortunately, Salinas passes away, she's sitting in a chair on this side of the table, and they're asking for her to go to prison for life or for a jury to have her put to death.
Yes.
But that didn't happen.
No, it didn't.
But would you agree in scene two, at that moment when that happened, everything changed?
Absolutely.
I mean, not only was scene one legally irrelevant, is that a fair statement?
Yes.
It was legally irrelevant. I'm not saying it's not factually irrelevant, it's legally irrelevant. Now, scene two, where Officer Salinas, when this attempted capital murder happened, that's when they're notified.
Yes.
Because he's standing there, may I stand up, Judge?
Yeah.
And he's saying, "You're going to get shot." And she says, "Shoot me."
Yes.
Have you dealt with situations or investigated situations where there was suicide by cop?
Yes, sir, I have.
We've heard a little bit about it. Will you just briefly explain to the jury what that is?
So suicide by cop is a phenomenon where an individual will intentionally provoke the police by threatening to use deadly force or actually using deadly force that ultimately ends with that individual's death. There's a lot of times that individuals want to die. They want to commit suicide by cop, and so that's why they're using that force. But there's also times that kind of fall into that definition when an individual may be suffering from a mental illness, whether they may be intoxicated, whether they might be on some type of drugs or situations where they, again, because of that intoxication or that illness or that the drug effect, they're intentionally provoking the police, causing them to do that. And it's simply, seriously, if you look at it in this particular case, what Melissa Perez did. As I told you earlier, when that first attack was made, and then she retreats from that first attack and then stops, and then that second attack, that's an intentional provocation. Whether she wanted to die or not, it really doesn't matter that it falls into the definition. It falls into the definition because of her intoxicated state, because that she was actually was intoxicated, and because of her mental illness that the officers knew nothing about. That resulted in forcing the officers to use force, and it resulted in her death. So by definition, it could fall into that term.
And I like that you used the word could, because we don't know for sure, but I'm just saying that is something that every officer is trained under and understands that could be a scenario, God bless you, that they could be under, correct?
Yes, that's true.
And so once we get into scene 3, and scene 3 is an effect or a consequence of scene 2 on that attempted capital murder. Scene 3 is Sergeant Flores arrives, Officer Alejandro, and then Officer Villalobos arrive at the scene. We've seen a lot of video on that.
Yes, sir.
And at that point, we have 15 officers. I believe we've heard a testimony that 15 officers and 2 other sergeants were at the scene.
Yes.
And the only reason why Sergeant Flores is calling the shot, so to speak, is because it's in his district.
That's correct.
Would you agree that if Sergeant Rivera and Sergeant Robertson disagreed with anything that was the plan that was about to be implemented, they not only could have, but they had a duty to say, we're not doing that.
They should have, if they had a duty, yes, if they disagreed.
And they could have stopped Sergeant Flores, called a lieutenant or a captain, and actually ordered the other men, we're not doing this. And
Yes.
there would have been some conflict.
That is true.
There would have been a showdown.
Yes.
And that could have happened.
Yes.
But that's not what happened.
No.
So we have all these officers there, and we have 3 sergeants, and everyone is agreeing that we have to do something.
Yes.
Because, would you agree with this? Is there any scenario, and we didn't hear it from witnesses they could have called or should have called or did call, where these officers are just going to go away and say, okay, Ms. Perez, turn yourself in, or we'll come back later when you decide you want to get arrested?
No, there's not.
There's no scenario where they're leaving.
That's correct.
Not only because she's attempted at least 2, and I'm 2 or 3, depending on how you look at it, 2 or 3 attempted capital murders, and then 1 assault on a peace officer, depending on how you look at that candle.
Yes.
That's number 1. They're just not leaving the scene without her.
They're not.
And then secondly, also because there is a gentleman in the room that you can't leave alone.
That's correct.
Because there was a question I'm sure you had. There was no evidence, Detective Soto said, of her showing violence towards the individual De Los Santos, Mr. De Los Santos.
That's what he said, and that's not the standard.
I understand it's not the standard, but that's what he said, right?
Yes.
And although she was being verbal, there was no evidence that she was going to be violent to the officers either.
That's what he said.
No, I'm just saying, but I'm asking, at some point there was no evidence that she was going to be violent to any officer.
Yes, absolutely.
Until she was.
Exactly.
Isn't that the way it works, that very few people say, I'm going to do this to you, it just happens?
Yes.
And you've seen situations where officers were tricked in letting their guard down, and then a suspect uses tremendous violence on them and either killed the officer or caused serious bodily injury.
I've handled those shootings, yes.
Miguel Moreno's one of them.
Yes.
And that happened here in Bexar County.
Yes, sir.
And so, but there's many others. And so those are training examples that all the officers go through in their in-service
Yes, sir.
and in the academy. Correct?
Yes, sir.
Okay. And so would you agree, and I believe Jason asked this question numerous times, because it caught my attention. Would you agree that Detective Soto gave a lot of liberty to Melissa Perez and nothing to the 3 officers behind me?
I agree with that.
In his statement, did you hear him say, well, there was no evidence she was going to let go of that hammer?
Yes.
Did you hear him say that?
Yes.
Was there any objective evidence to make that statement?
None at all.
He actually said to this jury that we don't know for sure if Maria Salinas was going to shoot her weapon. Remember him saying that?
Yes.
And did you read in her statement that she said she was going to discharge her weapon, but there was somebody in front of her?
I did.
But he said, even though she told us that in the statement, and even though he didn't interview her on camera, which he could have done, he made that conclusion about Officer Salinas, correct?
Repeatedly, he inserted his opinion, his personal opinion about what was going to happen without any evidence.
And are those examples of the bias that Lisa talked about, that Sergeant Miller talked about when she testified?
They are.
And is there any place for that type of bias in an investigation for murder, or for any allegation that the government is going to accuse a citizen of?
No, there's not. As a matter of fact, in my current position and past position, I've always told my investigators, I don't care what you think. What are the facts? What are the circumstances that you can prove, that you can show? Your opinion is not relevant in the final determination. It's what the facts and the circumstances and the reasonableness in this case shows.
Have you heard some detectives say that I look for the innocence when I'm investigating the case, and if I can't find innocence, then I lead towards guilt?
Yes.
And that's just a different style that you have, because many times officers, the same tunnel vision you describe to the jury in an incident, they can have tunnel vision in an investigation.
Yes, and in every investigation that we handle, even the murder investigations that we had, we would have an individual come in and have an excuse for what they did, or have a claim of self-defense. And it was my job to look at that and find out whether or not that self-defense claim was rational or not. We have to look at what the facts are, not what our personal opinions are.
And you had an opportunity, to review all the audit trails as well, correct?
I did.
And so we don't have to wonder, we don't have to guess. We know, and the jury's heard, we know what was looked at, what videos were looked at by Detective Soto or not.
Yes, we know.
And so we know that he didn't do a thorough investigation before he walked these warrants.
He did not.
And you heard him say to this jury that he made the decision, and I asked Sergeant Miller about this too, he made the decision to walk this warrant.
I heard that, yes, sir.
But I want to direct your attention now to the report. Captain Van Geffen's report. You read that?
Yes, sir.
What stands out about that report? What stands out to you about that report?
What stands out about that report in relation to Detective Soto's claim that he made the decision is that clearly he did not. First off, there is no decision by a detective to charge another officer with a crime that he has the authority to make. That decision is always going to be run up the chain. But specifically looking at Captain Van Geffen's report, in his report he indicates that as the ongoing shooting was happening, or as the investigation was happening, he met several times with command staff and the administration to discuss this case.
Real quick, I want to make sure we don't assume. What does command staff and administration mean, so the jury can understand?
Command staff, we're talking about, well, and we kind of use those terms that kind of interconnect. We talk about command staff, these are lieutenants and captains that are in charge of divisions and substations and the entire place. So we've got lieutenants, captains, and we talk about administration, we're talking about deputy chiefs, assistant chiefs, and the chief himself.
And so deputy chiefs, we call them DC, deputy chiefs,
Yes.
assistant chief, and then the chief himself, the chief of the police department.
Yes.
And so we know from Van Geffen's report that he met with the actual chief of SAPD.
Yes, as a matter of fact, we know from Sergeant Miller's testimony with Officer Pedraza that meeting occurred about 8:30 that morning, the morning of the shooting.
Okay, so there's a meeting with Captain Van Geffen in his report at 8:30 in the morning. How many hours is this after the shooting?
It's 6 hours after the shooting, 6.5 hours after the shooting, but 4.5 hours after the chief left the scene.
And you heard Sergeant Miller say that Sergeant Pedraza, at that meeting at 8:30 in the morning, a decision with the chief and the deputy chiefs and assistant chief, all the brass, they had already made a decision that these boys were getting arrested.
They made the decision that it was a bad shooting, yes, sir.
And so a bad shooting means people get arrested.
Yes.
Because it's either justified or it's not justified, right?
That's correct.
And if it's not justified, it's bad.
Yes.
And not that it's a good shooting, but they're meaning, good shooting is a term of art, meaning it's a justified shooting.
I apologize. I should have said not a justified
It's
shooting.
okay, it's all right. But that's, you're not being cold, that's just a term of art.
Yes.
Okay, so at 8:30 a.m., a decision was made between Captain Van Geffen and chief, assistant chief, and all the deputy chiefs that this was not a good shooting and that these guys were getting arrested.
Yes.
And then you heard testimony, and you can see this in the report. that sometime between 8:30 and 2:30, and we just don't know, based off the report,
Yes.
and Sergeant Miller testified to this, that Captain Van Geffen met with Mr. Harris of the DA's office.
He did.
And so you have a meeting 6 hours after this shooting. 6 hours, forget Soto, he's not in this meeting, right? Because it's not in his report.
No, he's not.
So Soto's not in this meeting. Captain Van Geffen is in this meeting with chief, assistant chief, and all the deputy chiefs, correct?
Yes.
It is determined it is not a justifiable shoot, correct?
Yes.
And at some point after 8:30 a.m. and before 2:30 p.m., Van Geffen, captain, meets with Daryl Harris, the gentleman to my left.
Yes.
And we don't know what that meeting is specified, but we know at that meeting, I think his report says, the decision was officially made
Yes.
to walk these warrants.
The report talks about reviewing body-worn camera and discussing the case, and a decision was made to charge the officers.
So you have a meeting, and is Detective Soto in that meeting?
No.
But Detective Soto sat right where you're at and told these fine people that he made the decision and that nobody influenced him. Did you hear him say that?
I heard him say that.
Do you have an opinion about that?
That is absolutely not true.
And would you give me some grace of why I'm so passionate? Because these men have been going through this for over 800 days. You understand that, right?
Yes.
Okay. Give me some grace, Butch. So now that is what we heard testimony to, and it appears to be consistent with a report from Captain Van Geffen, correct?
Yes.
Is there any reason why, any legal restriction why the government couldn't have called Captain Van Geffen to the stand?
None.
Why they couldn't have called Chief McManus?
None.
Why they couldn't have called any assistant chief?
None.
Why they couldn't have called any of the deputy chiefs?
None.
Why they couldn't have called any of the other 13 officers? May I stand, Judge?
Yes.
They were right there, and even they chose Chernak, who was on the other side, correct?
Yes, sir.
Rojas, because he's the original person, and they didn't call Ramos, did they?
They did not.
And Ramos is the one. Did he engage in de-escalation, Ramos, by the way?
Absolutely not.
He engaged, would you agree with this, and disagree with me if you want, he engaged in escalating techniques. Would you agree with that?
Yes, he did.
But they didn't know that, did they?
They did not.
But they had to deal with it.
Yes.
And so, what is that? As an expert investigator and instructor in this, is that just, there's bias, would you agree?
There's
I was going to say it sucked, but there's bias.
There's
You have
absolute
a
bias.
chief, I'm sorry, I don't mean to talk over you, Butch. I'll let you talk after this. You have a chief, you have an assistant chief, you have deputy chiefs, and you have a captain that meet together without this Detective Soto, make a decision without looking at any evidence, and then meet with the head of Civil Rights Division, this gentleman to my left, and then they all make a decision without seeing any of the evidence, hardly any of it, and charge these men with murder.
hardly any of it is correct, simply because the ink was barely dry on the statements that were printed out. The last statement was, I think, taken about 7:45 in the morning, if you believe that the time on the top is correct. Normally, when we conduct investigations and take statements, that time on the top of the statement is when we begin the statement, and it usually takes an hour, hour and a half after that. But Detective Soto said that was the end of it, and that's fine. If we want to go on that premise, that meeting occurred before the ink was dry on those statements, and all of the video evidence available, and it was impossible to take into consideration all of the evidence to determine whether or not this was a justified shooting in an hour before that meeting took place.
Is there any curriculum that you have not only taught, but seen anywhere in your 47 years where detectives, homicide detectives, are trained not to look at every bit of evidence, to include Chapter 9 justifications, before they walk a warrant and accuse someone of serious
It is
murder?
absolutely contrary to any training that I do or any training I'm aware of.
And is it normal for at that stage, I'm not saying get clearance from the chief and the command staff down the road after an investigation, but within 6 hours, is that normal for the chief and the command staff to have input on whether this case should be charged without looking at the evidence?
It is not normal, no.
Is it normal for that command staff, by conduit, by proxy, I use proxy because Captain Van Geffen is the representative, to meet with the prosecutorial agency, the prosecutorial branch that's going to be responsible for accusing these men, and then them commiserate and talk about whether this case should be charged or not?
That is not normal, no, sir.
And is it normal for the prosecuting agency to not have looked at all the evidence before they gave the okay and the green light to walk warrants on these boys?
Absent some clear criminal conduct, absolutely not.
And clear criminal conduct would be something on video, something that there's no justification, they were acting outside the scope of their authority, maybe they didn't have their uniforms on. We can think of scenarios where it was clear, and that's not this scenario here.
None of that existed here.
I want to direct your attention to Penal Code Chapter 2205, deadly conduct.
Yes, sir.
Are you familiar with that?
I am.
Would you agree that that statute has changed over the years?
It has.
Object to relevance, Your Honor.
Well, if you'll let me ask the question, I can tell you what it is.
All right, let me hear it.
And by the way, relevancy under 401 is any tendency to prove or misprove a material fact in the case, and I believe that somebody's charged with deadly conduct here, so it's very relevant. So how has it changed specifically?
The statute itself read that a person commits an offense if they point a weapon at an individual in a manner that causes them to fear bodily injury or death. And I'm not quoting exactly, but that's what it is. It places that fear in that individual. And it doesn't matter whether the weapon is loaded or not. That's one way to commit deadly conduct. Another way to commit deadly conduct is to actually discharge a weapon at or in the direction of an individual or a person. That itself, discharging it at them without hitting them constitutes deadly conduct as well.
And so that's what we said earlier, every officer that draws a weapon and justified in drawing the weapon to control the situation or defend themselves and thankfully not have to discharge it, there's definitely PC for deadly conduct.
Yes, there is.
Probable cause. And they could be charged technically with deadly
Technically, they
conduct.
could be, yes, sir.
And so would you agree that our legislature saw that and saw the problems with that, with maybe prosecutors that are overzealous, and they changed it in subsection C. They changed the statute. May I read it to you?
Yes, sir.
Do you want to try?
I don't know. He is bringing up evidence that occurred after this crime happened. It's irrelevant.
It's relevant because it shows that there was something wrong with the law at the time, and it's been corrected, and they should consider that.
Object to the speaking.
Well, then let's approach them, David. You're talking from the table. Subsection C. Are you with me still?
Yes, sir.
This section does not apply to law enforcement. Here's the key: engaged in the lawful discharge of the officer's official duties.
That's correct.
So it encompasses that reasonableness and whether an officer is acting within the lawful discharge of their duties.
Yes, it is.
Okay, and it's changed now. So the statute that was in place at the time that these things were walked warrants and charged and indicted, the legislature has corrected that now.
They have.
Because they obviously believe there was a flaw in it.
Yes.
And one last thing on Captain Van Geffen before we get into self-defense and defense of third person. Would you agree that Captain Van Geffen's report lists Melissa Perez as the suspect?
Yes.
Not as a victim,
Correct.
not as a complainant,
Yes,
as a suspect.
it does.
And the suspect is because she committed aggravated assault against peace officers.
Yes.
Amongst other felonies.
Correct.
So now I want to direct your attention to self-defense, defense of third person. Whenever a citizen accused of something as serious as this, you need to please read it.
Please.
It's okay.
Yes, sir.
So, and there's a claim of self-defense with a sense of third person. You would agree that the government has an extra burden.
They do. They have to disprove that.
They have to disprove it. So we talked to you weren't there, but we talked to the jury about this in jury selection. But whenever any citizen in this state says self-defense, I'm justified in this behavior or in defending a third person, there's an extra burden. So the state has the burden to prove someone guilty beyond a reasonable doubt, correct?
That's correct.
Way higher than probable cause to walk a warrant.
Absolutely.
Way higher than probable cause to get an indictment.
Yes.
Way higher than probable cause to drag any citizen into the courtroom like this and sit in a chair like this, right?
Yes.
Beyond a reasonable doubt. But they have an extra burden. They have to disprove self-defense beyond a reasonable doubt.
That's correct.
So it's like a double burden.
Yes.
They have to remove every reasonable doubt from a juror's mind that the actor did not act in self-defense or defense of third person.
Yes.
Okay. Now, when we get to 932 and 933, would you agree that not just officers, but every citizen in Bexar County, including the prosecutors, myself, the judge, we all have a right not to be victims?
Yes.
The question is, were we acting reasonable in that situation?
Correct.
And we can face deadly force with deadly force?
Yes.
If it's reasonable,
Yes, sir.
apparent,
Yes, sir.
and immediate.
Yes.
And so that's why I want to direct your attention. You mentioned it during your questioning with Tom, the Tula rule. You know what that is?
Yes, sir.
And they've heard a little bit about that. That was developed in 1986 by Dennis Tuller.
Yes, sir.
Okay, in California. Who says good things don't come out of California, right? I mean, so the Tula rule says, may I stand up, Judge?
Yes.
The Tula rule says that there's a training guide. It's not a law, but it's a guide that within 21 feet, if someone is charging at you with a knife specifically, but we can transport that to a force blunt object,
Yes.
that an officer will take, they have 1.5 seconds to draw their weapon, to
Yes.
get their sight on target, and to discharge their weapon in a manner, means, way that they could hopefully effectively defend themselves.
Depending on the level of security, 1.5, 1.67.
And so that 21-foot distance is ingrained in officers in the academy.
Yes.
It's ingrained in combat scenarios or training classes.
Yes, sir.
In use of force classes, it is used as a tool.
Yes, sir.
And there's actually exercises that you do where you have a marker and you're using simulated rounds and you're trying to create the same, they call it, you heard the term stress inoculation?
Yes.
You're trying to, may I push it? You're trying to create a scenario where you'll have them run, maybe go through dark scenario, rustle them up, and try to create this environment where the adrenaline is flowing and they have to respond appropriately within that 21-foot rule or get marked up by the marker.
That was actually part of the training that we did.
Yeah. And so you'll know by the marks on whether you got stabbed, shanked, or sliced by that,
Yes.
correct? But it can be applied to a force blunt object.
Yes, it can.
Can you explain to the jury what a force blunt object is?
A blunt force object is anything that can, when we refer to it, and especially in the medical examiner in a murder situation, it's anything that you can be hit with that can cause serious bodily injury or death. It could be a stick, it could be a hammer, it could be a rock, it could be a golf ball, it could be anything.
And so a rock could be a deadly weapon.
We've had DPS shootings where they were attacked with a rock and were required to shoot.
I mean, have you heard scenarios where a golf ball is a deadly weapon?
I have.
Where a golf ball can take out someone's eye if it's thrown at them just the right way, and actually you've heard of situations like that.
Yes, sir.
And so there's no question that a hammer is a deadly weapon.
Correct.
Now the Tula rule, there's been another rule. You mentioned that you did a course, a force science course. And is there a force science sprint study that kind of adjusts the Tula rule a little bit?
There actually is. Force Science conducted a study based on the amount of time an individual can sprint under certain circumstances. And in another study related to that, or the same study related to that, they measured the officer's ability to transport depending on the amount of equipment that they had. The table that they came up with actually extends that Tula rule from 21 feet to about 25 to 30 feet in 1.5 seconds based on that particular study. It was a peer-reviewed study in the Force Science book. I didn't bring that with me, but it's part of the Force Science Institute.
And when I hear it say, you're not saying force science, it's force, like use of force.
Yes,
Force
F-O-R-C-E.
F-O-R-C-E, force science. So I want to we talked about apparent versus actual danger and what the law allows. I want to talk about taser, shield, and beanbag, okay?
Okay.
So we've seen tasers come out. We've heard about taser training. Would you agree that a taser is a compliance technique, not a defensive technique?
Yes.
Is there ever a scenario in a self-defense course or use of force course where if an officer is being charged out with a knife, a blunt force object, or a gun, and they have a taser and a gun, that they are trained to pick up the taser?
No.
So when I say that a taser is a compliance, not a defense technique, if you tell someone you're under arrest, get down so I can handcuff you, and they don't, they can be tased.
Yes.
Is there any course that the government can cross-examine you on or present to you where an officer is trained that if they're presented with deadly force, that an officer anywhere in Texas that you know of is taught to respond with a taser?
None that I've ever seen, and I will never teach it.
And why will you never teach it?
Because it's not the correct response to deadly force. That taser has the ability to move, to miss. It has the ability, depending on how far that individual is from you. Let's say you try to use a taser where a guy is charging at you with a knife and he gets within 5 feet of you, and that taser does connect. The problem is that in order to get a good taser response, those probes have to get a good distance away so that the majority of the muscles will contract as a result of the electronic voltage being sent through them, and it causes them to be immobile. But the closer you are, the less those probes have to expand, so they can hit here in a very close situation, only affecting a very small portion of the body, and you won't get that response to where they stop what they're doing. Also, clothing makes a difference in a situation. Moving subjects make a difference in the situation. And I've even handled shootings and been on calls where this has happened, where we have tased somebody effectually and got a good probe contact, but it simply doesn't respond to them, and they're able to rip those probes out and continue the attack on the officer. It is not the tool to be used to defend yourself from deadly force.
Now, so that's when we talk about the taser as a compliance, not a defensive technique. Do you have an opinion of whether officers in today's law enforcement world overuse the taser?
They do, and they use them inappropriately in situations. I mean, we will have officers try and use a taser on an individual with a knife, and I can show you video after video that I use in my training classes that are catastrophic as a result of that. But officers are doing that more and more because they become to fear their ability to use deadly force to defend themselves, because they're concerned about not only repercussions from the department, but repercussions in the criminal world as well.
And being prosecuted like this.
Yes.
And you've seen that because they overuse taser at a compliance technique when it should be a defensive technique, people get injured.
Yes.
Not just the officer, but other citizens and other officers.
Yes.
How much force did any of the 3 officers behind me use at the scene against Melissa Perez when she was not charging at them with a hammer?
They didn't use any force. Their use of force in that situation was appropriate. If you watch the videos, when she was attacking, they used the appropriate force in drawing their weapons and being prepared to defend themselves against an actual or even an attempted attack. But when Melissa Perez stopped using force and backed off, you saw the officers holster their weapons. You saw them to retreat to tasers with the hope of being able to do that without having to use deadly force. But in every situation throughout this particular case, everybody acted appropriately when force was not being used and when force was being used.
And so we have no incidents where, and even when Officer Alejandro discharged his weapon to defend Sergeant Flores, he didn't keep shooting at her when she backed up.
He did not.
When the threat wasn't immediate, he stopped discharging the weapon.
Yes.
And would you agree in your experience that there's a couple of reasons why he shot left? Number one, under pressure, what is it called, and I'm not trying to embarrass him or be disrespectful, slapping the trigger. What does that mean?
There's a number of reasons that he missed, but slapping the trigger means that when you're on target, the whole idea in the firearms is to squeeze the trigger. You squeeze that trigger so you don't have movement of the weapon left to right, so you can stay on target. You get your sight alignment correct, and you squeeze the trigger so it's really the finger moving back like this. But when you get into a high stress situation, when you're excited, when that adrenaline dump hits and you're trying to defend yourself, that weapon comes up and police officers start shooting as fast as they can, and slapping that trigger, if you're right-handed, is going to cause that weapon to shoot to the left. And so that's why there are so many misses in officer-involved shootings. We're not as accurate as we are on the range because we're not under pressure, we're not under stress. We're concentrating on that trigger pull. But in high-stress situations, it's exactly what happens.
And you said a term, may I stand up, Judge? You said sight alignment. I want to make sure the jury's always with us. So sight alignment, these are sorry guys, it's a fake gun. There's 3 sights. There's rear sights and the front sight, correct?
Yes.
And sight alignment is aligning the front sight with the rear sight in order and then placing those sights on your target, controlling the recoil of the gun, which is how you handle it. And you're talking about that slapping of could
Yes.
cause it to do this.
And under controlled circumstances, it's easy to do, but in high-stress situations, it's not.
Right. But then also there's 2 other factors there. I mean, Officer Alejandro knew that Sergeant Flores was there, but he had no choice. So the natural tendency is going to be to stay away from his sergeant and try and pull left because Sarge was right here.
Yes, on the first volley, Sergeant Flores was right next to Officer Alejandro. The second volley, of course, you've got now Officer Villalobos closer to him. But there's a third factor that I hadn't considered until a little later on. You have to look at, and I'm sorry, but you have to look at Officer Villalobos. He's 5 foot something. And if you look at him in the video, okay? Alejandro, I'm sorry, Officer Alejandro. If you look at him in the video, this is his position as he's firing. His shoulders are actually up above because he's firing over that rail. And of course, this is not where you should be. This is where you should be. And so his aim is off because of his height. His aim is off because of slapping the trigger, and he's taking into consideration what's around him.
Sarge, and then also that those shards of glass coming at him don't help either.
They don't help at all.
And you testified earlier that any one of those chunks of glass, if it would have lodged into any one of them, but Sergeant Flores was the closest, that could have caused serious bodily injury or death.
Yes.
And when... Can I post, Judge?
Yes.
I'm showing you what has been marked as Defense 41. Have you responded to either fights at bars and or domestic violence where glass were thrown and bottles were thrown at people?
I've handled those cases, yes, sir.
Would you agree that glass breaking on someone's face, I understand that there's wax in here, in the one in our situation there's no wax, which actually makes it more dangerous. Would you agree?
Yes.
Because it's easier to break without the wax.
Yes, sir.
It's not as heavy, but it's easier to break.
Correct.
Have you seen the effects of glass just cutting, slicing people's face,
Absolutely.
hurting someone's eyes,
Yes, sir.
causing serious bodily injury?
Yes, sir.
This is not like the Western movies where John Wayne and everybody's smashing bottles on people's heads, and those are sugar glasses
Yes.
for movies. Glass fights and glass breaking is a dangerous endeavor.
Just getting hit with a bottle or a glass is actually capable of having a skull fracture, and which will cause internal bleeding. That's what we define as a blunt force object, unless, of course, it breaks, and now we become sharp issues that we have to be concerned about.
And so actually, depending on the legal evaluation, the throwing of that candle glass could have been an aggravated assault against a peace officer.
It could have been, yes.
If it would have hit Officer Salinas in the head and fractured his orbital socket, that would have been SBI.
Yes.
Right? And then she would have been charged with aggravated assault in that scenario as well.
Yes, sir.
The fact that it hit his arm and bruised him, that doesn't mean that wasn't still an ag assault.
Correct.
Okay. So now, I want to direct your attention kind of to the idea of this shield, because a lot of talk has been about a shield. Are they called ballistic shields or blunt force shields?
There are two types of shield. They're called ballistic shields, and then there are impact and riot shields, and there are two different types
So
of
let's
shields.
talk about those. We've seen situations where maybe there's a disturbance, there's a riot, and then you have officers, if I may stand, Judge. There's officers that have kind of like this, it looks like plastic.
It's made of polycarbonate.
And it's lighter than a ballistic shield.
Yes.
Much lighter. And then
Yes.
they have their asp.
Yes.
Or their mace.
Yes, sir.
And the purpose of that type of blunt force shield or a riot shield is because you're doing this and you're spraying, or you're doing this and you're striking.
Yes.
Right? That is the purpose of that type of shield.
That's correct.
The ballistic shield is not for that purpose.
It's not.
Ballistic means what?
Ballistic means it's capable of absorbing a high impact, or a high velocity impact. It's a velocity impact from a pistol. It can be a velocity impact from a rifle or a high powered rifle. They're designed to take that impact and distribute it across the shield without actually penetrating through the shield itself.
Judge, may I approach the witness? I'm handing you what's been marked as Defense Exhibit 125 for identification purposes at this time. Will you take the opportunity to look at that? And would you agree that that represents to be an SAPD
It does.
PowerPoint curriculum on what kind of training?
On ballistic shields.
Can you quickly look through there and see if officers are trained to use the shield against a blunt force object or knife?
I've looked through this, and I can tell you it is not.
How many other curriculums have you looked at through shield?
I look at, as a training coordinator for the Kendall County Sheriff's Office, I'm required to look at and approve curriculum for ballistic shields or any reporting that I do for another agency. So I have to have copies of their lesson plans and make sure that they're done correctly. And no lesson plan that's been submitted to me with ballistic shields talks about using that in any way for an impact
So
weapon.
nobody in Texas that trains on ballistic shields is trained to use them against hammers, against bats, against tire irons, or against knives.
That's correct.
Judge, at this time we move into evidence, defense 125, and I submit to counsel for inspection and no objection.
It's admitted.
Well, we happen to have a shield here. I'm going to use my Vanna White here as Jason Goss. And so, Jason's a big burly dude, but this is not a light thing.
It's not.
This is not the shield that you're talking about for riots where you're blocking and you're striking and you're blocking. The person holding this shield in a combat situation is not fighting.
That's correct.
They're the lead.
They're the lead.
And as we can see in those training, there's people behind them, whether it's a long rifle or handguns, they're positioned and formation behind them, keep moving, and they're going in because they're expecting gunfire, projectile, and they're expected to shoot back.
That's correct.
This is not where someone's fighting them with a knife or a gun or a hammer or a tire iron and everyone's sitting there like Spartans or Romans. This is not what it is. This is for combat with firearms.
With firearms, yes, sir.
And is there any scenario where somebody would use this to breach an apartment against people with blunt force objects?
There's no training scenarios that I've ever seen.
Would you agree that the individual in the front, back up please, hammer versus shield, which one do you want?
I want the hammer.
If you want to defend, we're in combat and somebody's got to go home, which one do you want?
I want the hammer.
I do too, because he can't do anything. It's here, I can do this, pull down, and then boom, come this way, I can come around this way. This does nothing against a hammer in an open combat situation.
It doesn't. And also what you have to consider, and there's actually, information to show us that ballistic shield is designed to, as I said earlier, it's designed to distribute ballistic high velocity bullets and separate and distribute that across the shield to keep it from penetration. It's not designed to distribute low velocity impact weapons. And so in this scenario, if Mr. LaHood were to hit in the area where Mr. Goss is holding the shield, that impact alone, just on the shield itself, on that impact alone on the shield itself could distribute that force through the shield itself and cause some type of injury to the hand or the arm that's holding it.
But it's ineffective against a hammer fight.
Yes.
And matter of fact, whoever's behind this person is going to have to use deadly force in defense of a third person against a hammer.
Yes, because this guy's not going to be able to do it.
Because the suggestion was made that...
Nico, you done with it?
Well, I know I need you still, brother.
Okay.
Try a better thing. So if this is the window, there has been some suggestions that put the shield up. That they put the shield in front of the window, and just what does that do to get Melissa Perez in custody?
It does nothing.
So would you agree that we have a shield holding the window, and now somebody's got to go through this door and still get into that engagement against a hammer, correct?
Yes.
So this changes nothing in getting Melissa Perez in custody.
It does not.
So tactically, this shield, and it seems like the 3 sergeants out at the scene and the other 13 officers figured it out. That shield was ineffective for this situation.
Yes, it was.
The tasers would have been ineffective for this situation.
They could have been, yes, sir.
The bean bags were ineffective for this situation.
Absolutely. When you're talking,
Explain that, please, why?
well, when you're talking about bean bags, again, remember you've got a projectile that's coming out of a rifle at an extreme amount of force. And the training that they will tell you is that if you use that bean bag within 20 feet, which I know we want to talk about the Tula rule, but if you use that bean bag from that shotgun round within 20 feet of the sub that you're hitting, then it's entirely capable for that bean bag to penetrate the body and cause serious bodily injury or even cause death, depending on where you hit them. So you've got to be a good distance away from an individual for that bean bag, at least for their own safety, if you're going to use it, to make sure that you don't inflict that serious bodily injury or death. And in this particular situation, we know that that distance that we're talking about, she would have had to been on the other side of the room, and the officer still would have had to been 20 feet away outside that balcony. It's not realistic.
And it's also, is it fair to say that it's mainly for an open field scenario where
Yes,
there's
it
not
is.
a lot of concealment or cover?
Absolutely. And again, in this situation, you're dealing with a small target. You're dealing with, yes, there is the ability for Melissa Perez or the police officer to have access to that window, but there's still an obstruction there to a degree for purposes of beanbag. But then there is also that moving target that you're trying to hit and be effective with, and it was just not possible.
But would you agree with this? Just the fact that the 3 sergeants at the scene and the other 13 officers were even talking about shields and beanbags, would you agree that they're still trying to at least contemplate a safer way to get Melissa Perez in custody, even though she didn't want to?
Absolutely, and that's was Sergeant Flores' intention by talking about. He took all of these things into consideration. Is there a shield? Okay, yeah, there is one, but is it really going to work? We've got less lethal information, but is it really going to work? And can we effectively put enough people on that patio to go through that door with a shield to accomplish our purpose? He took into consideration whether or not to use a key in this particular object. And if you listen to the video, when he asked for a key, he actually tells the maintenance man, but you know what? I bet that key's on a bunch of rings, and if we have to go through every one of those rings, it's going to alert her that we're coming, and so she's going to be able to attack. So we're going to take that out of the equation. Sergeant Flores took into consideration a number of ways to take Melissa Perez into custody as safely as they possibly could. And when his scenario and his plan actually came to fruition, she was not in a position to launch an attack. The thing that changed here was Melissa Perez attacking the
Her actions
officers.
changed it.
Yes.
So a plan is a plan until there's a plan B.
Mike Tyson made a statement, world heavyweight boxing champion. I don't know if you know who he is, but he made a statement and he had a quote. Everybody has a plan until they get hit in the face. And what he's talking about is every man that went against him in a fighting match had a plan how to beat him until he hit them. He changed that plan by hitting him in the face. Sergeant Flores had a plan. It was a plan that he thought out and went through all of the evaluations, and that plan was put into effect when he got in to try to make the arrest. Melissa Perez is the one that actually changed that equation and changed that plan.
But it was a plan that the Sergeant Flores developed by taking input from other people.
Yes.
Considering every option he could, even options that weren't tactically applicable, and he made that determination.
Yes.
And it was approved. That plan, obviously, this is not speculation, was approved by Sergeant Rivera and Sergeant Robertson.
Absolutely.
And it was approved because by all the other 13 officers at the scene.
Yes.
Now, there was some mention about, I think Mr. Luna said 15 officers, all of them are in shape against little old Melissa Perez, and I'm not being disrespectful, but it wasn't as if they were in, may I stand up, Judge?
Yes.
If they were in an open field, one Melissa Perez, 15 officers, no hammer, no weapon, that's a different scenario than the scenario they were in.
Yes.
So we had a very narrow hall of entry, we'll call it point of entry, very narrow. The back window was not a good way to enter, correct? Because it's a higher and it's a smaller window, and somebody is really exposing themselves, so that's not a smart way to enter, correct?
Yes, correct.
And so at that point, it didn't matter if there was 1,500 officers out there. There could only 1 or 2 go in at a time.
This was not Melissa Perez against 15 officers. This was Melissa Perez against 2 officers who were going through the door trying to make an arrest.
And at the time she attacked, they weren't even going through the door.
That's correct.
I asked you at the beginning of our questioning, our discussion, of whether you had arrested other officers before.
Yes, sir.
I mean, and investigated them, arrested them, and helped prosecute them and send them to prison.
Yes.
And you're testifying here because you evaluated this situation with all your experience objectively, without a personal stake in this, and you believe that they were justified in their behavior?
I will tell you that in 47 years of doing this job and investigating these cases, I've made thousands of calls on patrol. I've made thousands of arrests on patrol. I've investigated hundreds and hundreds of cases that I've filed charges on with the state and testified for the state in every one of those cases and supported those decisions. But when I looked at this case and I saw the rush to judgment to charge these officers, and I reviewed the investigation that was done by Detective Soto to charge these officers, and the misapplication of the law, and the misapplication of the reading of the law, and the misstatement of the facts of this case, there was no way that I could not testify on behalf of these officers.
And that's because you're getting paid a lot of money, right?
I'm not getting paid a dime.
You're not getting paid a dime?
I'm not.
So not even a per diem, nothing?
Nothing. I haven't been paid since day one.
And so you've been here for over 4 weeks, correct?
Yes.
And as you sat there as an expert can, you haven't been paid a dime?
No, sir.
How many hours did it take for you to review this case and do a thorough investigation that should have been done?
I've spent 300 to 400 hours or more on this case
And you have
over the
nothing?
last 2 years.
Not even a Happy Meal, nothing?
Nothing. Well, I take that back. I think Mr. Cifuentes bought us lunch one day.
Okay.
But that's about it.
That's your compensation?
Wasn't a Happy Meal, but
Good. You know better. But you're still working in your duties for Kendall County Sheriff's Office?
yes, but I'm not on duty at this point. Every action in my case on this particular case has been done off duty. I wanted to avoid any implications of misconduct or any appearance of impropriety on my behalf. So I've taken, all of this has been on my off time. I've used vacation time, and I work nights and weekends to make up for the time that I'm
Is that
here.
why you and I have been on the phone at 11 o'clock at night at times, because you're working at Kendall County Sheriff's Office?
Yes.
That's the witness, Judge.
I'm wondering if we might take a short break there.
Yeah, I think there's a juror that wanted one last break before they close the doors, so let's go ahead and take a short break. We'll let you know when we're ready.
All right, to the jury.
All right, welcome back, members of the jury. Defense, your thoughts?
May I proceed, Your Honor?
Yes.
Butch, I'm going to call you Butch.
Yes, sir.
I want to cover some things that I want to be sure, and I hope not to repeat what's been said before, but you did review grand jury testimony in this case, correct?
I did.
And did you agree that you reviewed transcripts of Chief William McManus's testimony in the case of Andre Vargas versus the city of San Antonio?
I did.
And he addressed that the San Antonio Police Department trains on Graham v. Connor, correct?
Yes, he did.
And you were in the training academy in 1989 when the Supreme Court came out with the decision of Graham v. Connor?
Yes, sir.
All right. And at my request recently, did you review a message that the chief sent to everyone in the police department back in March of 2016?
I did.
And in that message, did he explain to everyone that the San Antonio Police Department appears to...
Sorry?
Object to hearsay.
Okay. Did you rely upon the chief's message that he gave in 2016
I did.
as instructions from...
More direct witness?
Yes.
Is this something that you relied upon in the course of your regular preparation for the training classes you do, or is this something you relied on simply because they gave you that information to look at?
It's something that I relied on because it was documentation provided for me to form my opinion as an expert on whether or not these charges were justified and the use of force was justified. And it was given to me by the
By the
defense.
defense, right? This isn't something that you came up with on your own, right?
No, sir.
It's not.
It's not.
Okay. I object. It's just hearsay.
Your Honor, I believe it's proper, but if need be, I can lay further predicates.
Okay.
Butch, would you agree that the chief of police, William McManus, when he gave that message, he was giving instructions to his police officers what he expects a reasonable officer to do?
Yes, sir.
And so when the chief of police gives an instruction to the San Antonio Police Department, is that something you, in your expert opinion, believe that police officers can rely upon in deciding what's reasonable?
Yes, it is.
So in that March 2016 message, did he indicate that he does not expect officers to retreat when faced with danger?
Yes.
Did he indicate that he expects officers to adhere to the Graham v. Connor standard?
Yes. As a matter of fact, he said he wouldn't expect the officers to be held to any higher standard than Graham.
All right, and did you discuss fear or rumors that the department was going to impose higher standards that were more restrictive than Graham v. Connor?
He did.
All right. So based upon Chief McManus's testimony in the Andre Vargas case and his testimony, and his chief's message, would a reasonable San Antonio police officer believe that one must adhere to Graham v. Connor?
Yes.
All right, let's talk about, tell the jurors what TCOL is.
TCOL is the state licensing office for all law enforcement officers in the state of Texas. It's Texas Commission on Law Enforcement. In the past, it's been known as TCLOS, Texas Commission on Law Enforcement Officers Standards and Education, but they shortened it to TCOL. They provide information on the requirements that we need to have to pass the academy and be licensed as a peace officer. They also issue mandated training for us to keep our license and to advance in certifications as we are police officers.
All right. And does TCOL have a proved curriculum for officers' use of force?
Yes, they do. Excuse me. Yes, they do.
And do you teach that course?
I do.
And do you review the curriculum or outline for that course?
It is mandated, because it is a mandated course, I have to follow that curriculum and outline, so I'm familiar with it, yes.
And so does that curriculum apply to San Antonio police officers and all police officers statewide?
It does.
And does that curriculum teach the Graham v. Connor standard?
It does.
And what is Graham v. Connor, for the benefit of the juries?
Graham v. Connor is a United States Supreme Court case that dealt with an officer's use of force and set the standard and actually changed the standard on how officer uses of force is going to be judged. Before Graham v. Connor, it was judged under the Eighth Amendment, cruel and unusual punishment, and that required some proof of an officer's bad intent or malicious conduct in the case to determine whether or not their use of force was justified. Graham v. Connor came along and changed that standard and put it under the Fourth Amendment of the United States. And what it did was it created an objective reasonableness standards. We're not going to look at whether the officer had good intent or bad intent. We're not going to look at certain circumstances that we looked at previously. We're going to set the standard to say that in order to determine whether an officer was reasonable in their use of force, it will be set on an objective reasonableness standard based on the totality of the circumstances.
All right. Now, would you agree with me that Graham v. Connor set forth several factors, and I want to go through some of those factors? You agree that there were several factors?
Yes, there were.
All right. And would you agree that one of the factors is that proper application requires attention to the facts and circumstances of each case?
Yes, they do.
All right. So I want to digress a little bit. Forgive me for saying, but you had an excellent PowerPoint presentation. Would you agree that it took you some time to put that together?
Yes, sir.
All right. And you were able to put that together by reviewing all of the available digital media evidence of the 15 officers on scene from beginning to end, correct?
Absolutely.
How many times did you review it?
I didn't actually count, but if I had to, I'd say 20 to 30 times.
All right. And did you have the benefit of a complete transcript of each body-worn camera to assist you in your review?
I did.
And did that complete transcript have timestamps in the transcript?
Yes, sir.
And can you tell the jury whether having the benefit of those timestamps in the body-worn camera enabled you to evaluate the facts and circumstances of this particular case?
It did, yes, sir.
And can you explain to the jurors whether, in your opinion, Detective Soto or Captain Van Geffen or Chief McManus would have been able to evaluate the facts and circumstances of this case when the arrest warrant was signed on June 23rd, 2023 at 6:23 or 6:45 p.m.?
That is not possible.
All right. And when you obtained quotations in your PowerPoint presentation, did you have to go, can you tell the jurors whether in counting the number of times she said she wasn't going to be arrested or the number of times she said the officers needed a warrant, whether you had to go to different body cameras?
I did. I had to review different angles and different cameras.
All right. And so by doing that, that consumed a lot of your time?
It did.
All right. And is that part of the reason why you have the opinion that there was a lack of careful attention to the facts and circumstances of this case when the warrant was obtained?
That was part of it, yes, sir.
All right. And so the Graham standard also includes the severity of the crime at issue. In this case, what we know from what Mr. LaHood said is that there's different scenes.
Yes, sir.
And the initial concern would have been with the fire alarm system. You understand that?
Yes, sir.
And even though it's a property crime, the fact that it involves the safety of maybe 100 people in an apartment building, that in itself would be considered a severe crime under the circumstances.
Yes, sir.
And would you agree with me that aggravated assault on a peace officer or attempted murder or attempted capital murder of a peace officer is a serious crime?
Absolutely.
And so at 1:40, 51 or so, Melissa Perez based on your slide presentation, attempted to strike and did assault Jonathan Salinas. Would you agree?
Yes, sir.
And would that be a serious crime?
It is.
And since we're on that point in time, if I could have that slide? Sure. All right, so we're showing you a slide of Melissa Perez from Officer Ramos' body-worn camera, and the timestamp is 01:41:09. What do you notice about Melissa Perez's head at this time?
Her head is outside the window.
And what does that tell you about her ability to locate and visualize her target?
It absolutely makes it able for her to do that. She's able to turn her head and look in that direction, that 180 degree direction that she's capable of seeing.
All right, and you already have addressed that there was no obstruction, but the fact that she's able to stick her head out the window, does that further refute the claim that Detective Soto made that there was an obstruction that blocked her ability to strike?
It does.
And based upon the failure of Detective Soto to describe this moment at 01:41:09 on Detective Ramos' body-worn camera, does that tell you whether he failed to evaluate this case by paying careful attention to the facts and circumstances of this case?
It was a clear omission of those facts and circumstances, yes, sir.
And you know that before 01:41:09 that she attempted to strike Jonathan Salinas twice.
Yes, sir.
And was that an omission that failed to address the severity of her criminal conduct at that moment in time?
It was a clear omission, yes, sir.
All right, and so when we fast forward, let me go ahead and take that down. When we metaphorically fast forward to the time that Melissa Perez attacked Nathaniel Villalobos at around I believe it was 1:51:55 or so, was that also a serious crime when she attacked Nathan Villalobos with a hammer?
It was.
And was that also a failure to address the severity of the crime at issue?
It was.
And does that also show a lack of attention in the facts and circumstances of this case?
Yes, sir.
All right. And would you agree that when she was engaged in that conduct, she was actively resisting arrest?
I would.
And is that a factor that the Supreme Court at Graham v. Connor says should be taken into account?
It's an absolute factor, yes, sir.
All right. And in Graham v. Connor, does the court admonish the reader and judges that you must put yourself in the perspective of a reasonable officer on scene?
It does.
And in your review of this case, did Detective Soto fail to put himself in the shoes of Alfred, Flores, Eleazar Alejandro, and Nathaniel Villalobos?
He did, and he admitted he did.
All right. And is that a violation of the directive in Graham v. Connor from our Supreme Court of the United States?
It is.
All right. And did the Supreme Court of the United States admonish that you must put yourself not only in the shoes of the officer, but you cannot judge them with 20/20 hindsight?
It does.
And did, in your opinion, your expert opinion, did Detective Soto attempt to judge them with 20/20 hindsight based upon his assumptions?
He did, and he admitted that he did.
And when he did that, would that be a violation of the directive in Graham v. Connor?
Yes, sir.
All right. Now, as part of your review in this case, let me back up. You indicated that you attended the Force Science Institute. And forgive me if I'm ignorant, but isn't there a little bit more to the Force Science Institute than you've told the jury? Is that considered a prestigious institution, one of the best schools in the country?
It is, and they engage not only in training, but in peer-reviewed scientific research to back up the theories that they teach.
All right, and so when you attended that school, did you just show up for a day or so, or did you do something more intensive?
No, so it was a 400-hour class over several months that not only required in-class attendance, but discussion groups. We had lectures by doctors involved in these areas, specific areas of attention and memory and human performance. We had to analyze cases, and we had to pass a test based on our analysis of those cases, and we had to prepare a written report on a case that we analyzed to be able to pass the training.
All right, so did you attend that by going in person to wherever this is located?
The first class that I did was an in-person class. I guess I should tell you, this is the second attempt at that class. I went through that class in Chicago the first time, and just as I got to the end, my daughter again had a medical emergency and went into emergency surgery, so I could not attend the 3-day evaluation, so I didn't get credit. So I waited a couple of years and was able to reapply and go back through the class. It was online, Zoom meetings, and research and study based on that.
All right, you said you had to apply. Can anybody get into the class?
No, sir. They have some requirements that they base it on. They want to make sure that the individuals that are attending this class have not only the educational background, but they're actively involved in this type of work, so that what they're teaching is actually applied in this area.
So I know you're a humble person, and I'm not trying to embarrass you, but you have to be pretty good to get into that school or class.
Yes, sir.
Agree?
Yes, sir.
All right. And when you complete it, do you get a certification?
I do.
And what is that certification?
The certification that I have for the last class that I took was the Advanced Force Science Specialist. Again, it's the highest certification that they offer.
All right. Now, getting back to materials that you reviewed, as part of your review, did you review Chuck Joyner's expert report that the state provided?
I did.
Did you review his supplemental report that he provided within the last week or two?
I did.
And did you read a copy of his book that he wrote on police use of force?
I did.
And do you agree with his statement in his book that women who are suspects of misconduct can be equally as dangerous as men?
I do.
And so, given what he said in his book, applying that to Melissa Perez and what we saw in the videos, could she be as dangerous as a man wielding a hammer as aggressively as we saw her in the videos?
Not only in her gender, but in her work history and what she did for a living, it certainly makes her a danger.
All right. So let's break down a couple of things regarding that. First of all, you reviewed CPS records. I think that you may have alluded to that. Is that correct?
Yes, sir.
And so the CPS records indicated that she was a roofer.
Yes, sir.
And I believe in the video that Detective Soto had with family members, they mentioned that she was a roofer.
Yes.
Okay. And so, in getting back to Chuck Joyner, who is Chuck Joyner?
Chuck Joyner is a retired FBI agent. He worked previously in the CIA, and then he changed careers and went to the FBI. He is a recognized expert on use of force, but his expertise in that area, and he's got some background in SWAT and other special assignments that he did, but his expertise is more in the actual application of force, how to do the defensive tactics that we use, how to defend yourself in that type of a situation. To my knowledge, he's never investigated an officer-involved shooting case and never analyzed an officer-involved shooting case.
All right. And so, given what you saw in the body-worn cameras of Melissa Perez, is there any doubt in your mind that at 2:02:04 to 2:02:07 that she was engaged in a deadly charge that was aggressive, swinging the hammer and potentially striking Alfred Flores in the back of his head?
No doubt at all.
All right. And based upon your review of various body-worn cameras of that moment in time, using the Graham v. Connor standard, did Eleazar Alejandro act reasonably at 2:02:07 when he fired 5 shots at Melissa Perez?
Yes, he did.
Why did he act reasonably?
Because he was defending a third person under the statute itself and under the current case law.
All right. And we've seen in the videos that Melissa Perez retreated to the hallway between the kitchen and the living room, and she stood up, faced the patio door, and when she was facing the patio door, it was approximately 2:02:10 or 11. Do you recall that?
Yes, sir.
And you saw that she had a purposeful look towards the door for at least a minute, at least a second or two, and then began her charge somewhere around 2:02:11 or 2:02:12, correct?
That's correct.
And when she charged towards the patio door, when Eleazar Alejandro and Alfred Flores fired 5 and 3 shots, did they act reasonably under the Graham v. Connor standard?
Under Graham v. Connor, as well as Chapter 9 of the Penal Code.
And why is that?
Because Chapter 9 allows an individual to use force when, to the degree they reasonably believe it's immediately necessary to prevent the other's use of unlawful force or attempted unlawful force. And then analyzing that under the Graham v. Connor standard of totality of the circumstances and objectively reasonable, he meets those qualifications as well.
All right. And as part of your expert analysis, did you review a court decision that discussed facts similar or nearly identical to this situation?
I reviewed a court decision that dealt with the exact circumstances of this case, yes, sir.
All right. And after you reviewed this court decision, did they reach conclusions similar to yours that the use of force in this case was reasonable under Graham v. Connor?
They did. The judge in that case ruled that the officers did not use excessive force, that they acted reasonably under Graham versus O'Connor, and that there were exigent circumstances for them to do so.
All right. And whether someone's schizophrenic or not, in that case, when someone's charging at officers with a blunt force instrument, does that create an imminent threat of serious bodily injury or death?
It does.
And when they close a distance similar to this case, does that cause a peace officer to reasonably believe that it's necessary to use deadly force to defend themselves or fellow officers from serious bodily injury or death?
It does.
And when you reviewed the facts of that case, did the judge require that the police officers retreat after the suspect charged at the officers in that case with a blunt force instrument?
The judge in that case did not require it, nor does Texas law.
All right. And do you agree with that under Texas law and also Graham v. Connor?
I do.
All right. And just so there's no doubt, would you agree with me that when Jesus Rojas failed to arrest Melissa Perez when he had the opportunity to do so at 12:44:32 and had that opportunity for 2 minutes, that the issue of mental illness, emergency detention, was not an issue in the totality of circumstances in the Graham v. Connor when the officers used force at 2:02:07 and at 2:02:13 through 2:02:17?
It was not.
All right, and why is that?
We talk about the reasonableness of the officer's action, that being objectively reasonable. We look at the reason that Sergeant Flores, in this case, made the decision to arrest, and the other two officers were attempting to, or Officer Villalobos was attempting to arrest as well. That is that subjective idea, that idea of, I think that based on everything that I have, this is my plan, and this is what I'm going to do because I believe it's correct. Now we look at objective reasonableness. We take his opinion out of it because the courts have said that if our subjective opinion was all that mattered, then we'd always be right. But that can't be the standard because we know sometimes we're not. So what we're going to do is we're going to take your subjective opinion, your belief that you were right, and we're now going to analyze it by looking at all of the facts and circumstances that are involved in this particular case, and determine whether or not your reasoning was justified or reasonable or not. Based on this particular case, Sergeant Flores, Officer Alejandro, and Officer Villalobos had no indication and had no knowledge that Melissa Perez was suffering any kind of mental illness or mental break. All they knew and evaluated was her actions at the scene that, as we talked about before, could appear to be an intoxicated person, and in fact she was. So now let's look at all of those facts and circumstances to determine whether or not your decision to go in and arrest her at that time, okay, was reasonable, and we can not only look at what was going on at that time, but in determining facts and circumstances, we can look at all of the information that we've gathered at that particular time to say, did he make the right decision based on what he was doing at that time that he believed was reasonable from a person being in his perspective. Is that clear?
So one of the things that I want to digress upon, and I'm going to try to close quickly, but can you explain to the jurors the importance of action-reaction time from the perspective of a police officer and how they're trained?
The action-reaction is one of the things that we take into consideration because it allows us to determine, it kind of gives us a heads up of what could happen, what our human performance abilities are. To give you an example of what we're talking about, one of the examples that I use in class, and we talk about it being science, and there are people that are going to say, science doesn't mean anything, but the simple things can be considered science. So if I were to have you hold your hands up here, you don't have to do this, but if I was to have you hold your hands up here, and I was to tell you, when you hear me say go, okay, I want you to clap your hands before I do, okay, because we're going to hold them up at the same time. And when I say go, I'm going to do this, and I guarantee you none of you are going to be able to do it before I do. That means, as the suspect in this case, I'm always ahead of you. I've always got some advantage on you in order to use that force against you. So we have to try and determine how long it takes us to respond to that, and we know that. We know that it takes at least 0.56 seconds for the brain to say, this is what I want to do, send a message to the arms or the hands to do it. That takes another 0.2 of a second. So about 5.6. We are always behind the 8 ball or behind the suspect by at least a half a second or more. What you have to think about is if we're in a shooting situation, if it takes us a half a second to react and it takes us another second and a half to get our weapon out of the holster, then that individual has the capability of firing 4 shots, at least 4 shots, and this is based on scientific studies by Force Science. They have the capability of firing at least 4 shots before we can even get out of the holster and be on target. Take that into a blunt force object, it's a little bit slower, but you're also seeing that you have the ability to strike and injure or kill an officer based on the number of strikes you could do before I have the ability to react to what it is you're doing to me. So we are always behind, and we try and understand that so we can train officers how to respond to that.
All right. So I think that the next question that I have along those lines may be clear, but just in case. Based upon that training, are officers required to receive an injury before they can use force?
They are not.
And why is that?
Because of that particular incident, because we're behind the 8 ball, we're not required to wait until we get hurt. We're not required to wait until actually, and one of the things that I teach in classes is if I'm standing here, okay, talking to a suspect that's in front of me, and as that officer I'm standing and talking, okay, that individual takes a sidestep and he kind of blades his body towards me. We know from our training and experience and that's a fighting stance. They're getting ready to take that balance to get ready to strike. And also, as I see that individual ball his hand up, he's been aggressive and threatening, but he balls his hand into a fist, okay? And I know as an officer, based on what I'm seeing, an attack is about to happen. I'm not required to wait for that attack to happen until I can use force to defend myself. If I see that coming, I'm able, and a private citizen who was viewing something like that would go, oh my God, that police officer just hit him for no reason. But that's why we ask questions in these investigations in the statement. Why did you use that force at that particular time? What did you see that justified you taking that action when you did? I hope that explains it.
So, one of the things that you did in your PowerPoint presentation is you presented how many times Melissa Perez said that she was refusing to be arrested, go ahead, shoot me, and on and on and on, and there's probably 40 or more instances that you cited. Is that what the Supreme Court and Graham v. Connor references when they say the test is whether the suspect is actively resisting arrest?
That's part of it. The resisting can be verbal, as it was here. No, I'm not coming out. I'm not going to comply with your orders. And in those situations where an individual is actually resisting verbally, if it was a one-on-one situation, we would be justified in using the taser in that situation. But that's something to consider. But also in the Graham v. Connor standard that we're talking about, her actively resisting arrest was her actively attacking the officers.
All right, so the 3 times that she swung the hammer at Jonathan Salinas, Nathaniel Villalobos, and her statements that she was not going to be arrested, that would inform the officers that when she was charging at them at 202:07 and 202:13, that she had the intention to use the hammer as a deadly weapon to cause serious bodily injury or death.
Yes, sir.
And that belief would have been reasonable.
Yes, sir.
And that they didn't have to wait for that to actually happen to use deadly force.
No, sir.
And is that consistent with the use of force continuum or the use of force matrix that's taught by TCOL?
It is.
All right, explain the use of force continuum or use of force matrix as taught by TCOL.
The use of force continuum and use of force matrix, the terminology has changed over the years since 1977 when I started up until now. And we've seen changes in terminology and changes in diagrams to help officers understand it better. But the premise of what that diagram and that system is simple. If it tells us when we would be authorized to use force or when it would be reasonable for us to use force in a particular situation. It goes for if a person is not actively resisting, it's passive and verbal. Then at that point, we're only going to use verbal commands to stop them. We're not authorized to go hands-on. When they escalate that or change that to actively resisting, now we're going to go hands-on, which basically means we're going to use physical force, hands, fists, and feet, to get that individual to comply and get them under arrest. And we're able to use, if they're actively resisting, intermediate weapons like TASP and ASP and tasers, and pepper spray, what other intermediate weapons that we have to accomplish that goal. When the individual escalates force from active resistance to now they pick up a weapon, then that changes their perspective. And even in Mr. Joyner's diagram that he talks about in his book says basically the diagram that he came up with use of force basically says anytime there's a tool or a weapon, deadly force is authorized under those circumstances. So even his definition of deadly force is authorized because you're using a tool or a weapon. And a tool was obviously the case here.
All right, and I believe you addressed Deanna Plott. She attended your course in Kerrville or Kendall County?
She did.
All right, and did you have a chance to talk to her at that course?
I did.
And can you relate to the jurors the conversation you had regarding this case?
There were 6 officers from the San Antonio Police Department that attended my course, and we were actually talking about taking statements from officers in an officer-involved shooting in that particular segment of the class. On the break, I spoke to Deanna, and she came up and asked me if I was involved in the case. I told her that I was going to be involved for the defense, but we couldn't talk about any facts or circumstances. And I asked her if she was involved in the case, and she said yes, she took a statement. Because we were talking about taking statements in the class, and I had just finished talking about asking questions and delving into the why, she made the comment that when she took the officer's statement, she specifically didn't watch any of the video because she didn't want to be influenced by what she saw on the video. She didn't want to inject any bias in that particular situation. But that's not injecting bias, and my response to her was, wait a minute, if you don't watch the video, if you don't know about the facts of what happened, then how do you know what questions to ask to get to the direction to determine whether or not the justification existed? That practice doesn't make any sense. That's why it's critical, even in officer-involved shootings, when I was investigating them, our shooting team would meet and the detectives would talk about, okay, this is what we know happened at the scene, this is what we're looking for, this is what we need to address. All of that information needs to be shared with those officers, because how do you expect the lead detective to come up with a proper analysis if the detectives that are assisting and retrieving that information don't ask the questions to give that detective the right response or analysis?
All right, so let me bring that back to Graham v. Connor. Given her answer, do you have an opinion as to whether, giving that attitude of Deanna Platt, whether she had the ability to do a careful analysis and give proper attention to the facts and the circumstances of this case?
I will tell you, based on the statement that she took and reviewing this case, at the time this case happened, my answer is no. Of course, I want to make sure this class occurred after the officer-involved shooting occurred, but based on the information that she obtained in this case, then no, they did not do it thoroughly.
All right, and based upon her answer to you and based upon having seen the statement that she took, did she have the capability to include the severity of the crimes at issue involving Melissa Perez in the decision that these officers faced?
She did, and she chose not to.
All right. And did she have the ability to properly evaluate whether Melissa Perez posed an immediate threat to the safety of the officers on scene?
She did, and she chose not to.
And based upon her answer and based upon the statement she took, did she follow the Graham v. Connor standard on whether Melissa Perez was actively resisting?
She did not.
Now, in Detective Soto's affidavit, he makes the statement that the officers could not have reasonably believed that Melissa Perez posed a clear danger to the officers. Do you have an issue with that?
I certainly do.
And what is that?
Detective Soto clearly did not analyze the justification uses of force in here. Not only did he add information into the warrant that was misleading to the magistrate, who may have decided after reading everything that should have been put into the warrant that I'm not going to sign a warrant for murder when there was clearly justification in this case. But his miswording, and it's intentional, that's my opinion, that by putting statements in there that was only favorable to the decision that had been reached earlier was a disservice to these officers, because it did not allow the magistrate to review all the facts to determine probable cause, or even the elements of the offense of the case.
All right. Now, getting back to the court decision that you reviewed that's similar to this case, did the magistrate judge in that case say that you cannot analyze the facts of a case from the comfort of the judge's chamber, but you must consider the tense dynamic circumstances facing a reasonable officer?
He did.
And what does that mean to you?
That means exactly what Detective Soto did in this particular case, and what the administration and everybody else did in this particular case. They sat back, They looked at what happened in this case. They looked at the flawed information that they were given that didn't provide justification for this case. And they basically said, because of what the officers did, I don't like it. I don't like the fact that they did this. I don't like the way that it looks. I don't like that this appears to be improper. And they made a decision based on personal opinion. Detective Soto basically said the same thing by giving his opinion in his testimony. I don't like what happened. We can't put people in jail because we don't like what they do. We have to put people in jail because they violate the law and there's no justification for what they did. And that was not the case here. This case was an opinion, the decision was opinionated to the point where it wasn't justified.
All right. And one last thing. You consulted with Kimberly Bauer, Lisa Miller, and Raymond Roberts?
I did.
Okay. And who are they?
They're all retired, well, they're all retired San Antonio Police Department. All three worked for me as murder investigators. When I was the sergeant in homicide, I actually recruited, Ray Bob was already there, Raymond Roberts was already there, but I recruited Lisa and Kim to come to murders from sex crimes. So we all worked murders together.
All right. And all four of you were retained by me, correct?
Yes, sir.
And I apologize that I only gave you lunch, but you're okay with the fact that even though I retained you, that it was better and simpler for these other attorneys to question you and Lisa first?
Absolutely.
You're okay with that?
Yes, sir.
All right, thank you very much.
Yes, sir.
Jackson, how are you?
Good, how you doing?
We've known each other a long time.
It has been.
Hope you're enjoying your time out in Kendall County.
It's the greatest job in the world.
When you work as a detective there or a lieutenant here, and you supervise investigators there, so isn't it true that sometimes before you have a case that's presented for indictment or filed, that you'll talk to the district attorney's office about the case and what you got?
It is true in some circumstances, not always. I prefer my investigators not do that because I want them to learn how to investigate cases and get involved. But there are times we seek advice, yes, sir.
Would you be surprised if that happens all the time in Bexar County?
No, I worked in Bexar County. I'm familiar. We would ask questions.
Right. There's a dialogue that often happens.
There can be. I was mostly not a part of that, again, because we wanted to investigate our cases and make our determination. At the end, we would contact you.
But you are and have been a law enforcement officer your whole adult life,
Pretty much.
right?
Yes, sir.
How old were you when you started?
22.
22 years old.
23. I'm 70 now.
The people that you have surrounded yourself with, and the people that you know, and the good friends that you have are in law enforcement,
Yes, sir.
right?
Yes, sir.
How many people in your life are like Melissa Perez?
In what sense, sir?
Well, I mean, people that you spend time with, family member, someone that you're close to, that goes through these kinds of issues and problems.
Well, I have to tell you, my family is not the greatest. I've arrested my cousin for possession of controlled substances. I've got people that are in poverty status. I have people who are drug addicts. I kicked my brother out of my house when I was on the police department because he was using marijuana. I pretty much have experienced a lot of what's going on, and I do have individuals in my family that suffer from mental illness. So that is a big part of my life.
I mean, I guess the point is we all have them,
Yes.
right?
Yes.
I mean, everyone you know has these folks that are troubled,
Yes, sir.
that have issues and so, right? And that they can still be loved.
They
right?
can.
They can be misunderstood,
They can.
right? They can put themselves in situations where you would hope that the government would take some time to assess them before they jump in on something. Do you agree?
If circumstances permit, yes, sir.
Right, I remember kind of as we all went through the George Floyd time period and all the protests and all the interactions and, the things about, well, I have an autistic teenager and I'm afraid that if he's driving on the street that an officer may misunderstand that what appears to be his disobedience, right?
We have those, and I've investigated those cases as well, so it does happen.
And law enforcement has to, and they do now, even more so, train officers on kind of recognizing those signs, or trying to.
They're trying to with the issue of mental illness, yes, yes, sir.
Well, because it's important, right? It's
It can be,
important,
yes, sir.
Right? You had said, and you repeated a minute ago, that in the officers that you supervise there, that are doing investigations, homicide investigations and other things, you tell them, leave your opinion out of it, just gather the facts.
Leave your opinion, your initial opinion out of it as you gather facts. I will not have a detective coming to me and saying, I think this person did this. No, go find the facts, analyze those facts, and give me a reason for believing that is factually, objectively factual to determine whether or not the crime existed. Did they meet the elements of the offense? Did they have the criminal intent, the right criminal intent to commit that particular offense? So leave your personal opinions out of it. Let's analyze this based on an objective standard.
But ultimately, everyone has opinions.
They do, and we're supposed to try and control those opinions as best as we can. That's what I look to do, not only in my investigations, but my people's investigations as well.
In a criminal trial like that we're at here now, the only opinion that matters, right, is the jury's.
In this process, yes.
Right?
Yes.
And you were talking about, the standard that the jury will be given, and that's to determine what an ordinary and prudent person would have felt or perceived given the circumstances that these officers were in. Would you agree?
Object, it's not what an ordinary person, it's a reasonable officer.
The charge will speak for itself. A reasonable, ordinary and prudent person.
And you can answer that.
I can answer that by referring to the statute and what it's supposed to talk about. And the statute talks about a person has the right, to use force to defend themselves when and to the degree they reasonably believe it's immediately necessary to defend themselves against another's use of unlawful force. Now, that reasonableness standard is defined in Chapter 1 of the Penal Code, and it talks about putting an ordinary, reasonable person,
Ordinary and prudent.
ordinary, prudent, reasonable person under those same circumstances.
Right. So, and you expressed it well. It's not, like you said, it's not what the officer thought, right? Because in that time, nobody would ever be convicted, or the person charged with using deadly force against another. It's this ordinary and prudent person.
It's what the officer thought, but was that thought, that subjective intent, was that subjective intent reasonable under the circumstances based on a reliance from an ordinary, prudent person?
Right.
Yes.
It's what the ordinary and prudent person standing in the shoes of that, in this case, officer, right?
Yes.
What they perceive.
Yes,
Right.
if I'm looking at an ordinary person and I'm sitting in my house and there's an individual with a hammer that's running through my back door, through my plate glass back door, how am I going to react? Or if I'm an ordinary, prudent person facing an individual charging me with a hammer that I know can kill me, how is that individual going to react? And is that reaction reasonable?
What is your understanding of the word prudent?
Prudent is just an ordinary person. I'm sorry, I can't give you a definition for it, but prudent, I would opine that it is a reasonable person.
Well, it's kind of, you're in circles there. You can't define reasonable as prudent and then say prudent is reasonable. Right?
Well, I actually don't know the definition of prudent from memory, so I would have to say, if you ask me about careful, I would agree with that.
Right. An ordinary, careful person.
I have no problem with that.
You talked about Graham v. Connor a lot. Graham v. Connor is a federal court opinion, Supreme Court opinion.
It is.
And it isn't a criminal case. It was before the Supreme Court in Graham v. Connor. It was a liability of a police officer in an officer-involved force.
Most of those cases, you're right, are basic liability, but the fact that it's a federal opinion does not negate the fact that it applies in criminal cases, because in Supreme Court cases, when we talk about Fourth Amendment cases, whether or not the search is reasonable, the entry was reasonable, the seizure was reasonable, those standards, even though they're decided by the Supreme Court, are applied to Texas law enforcement officers as well, that you and I both argue every day in the cases that we prosecute, and I file with you.
It uses the term reasonable belief, right?
Yes.
But what it's used for is essentially, and the reason why it's used in the trainings that you get in law enforcement agencies across the country is it's to help officers protect themselves from civil liability.
If we're talking about Graham v. Connor and that application, the concept that it protects you from civil liability, you're absolutely correct. But the premises that are determined by these cases, by these federal cases, are ones that are applied in everyday law enforcement practices. But yes, it protects us from civil liability, but it also directs us in how we're supposed to act in everyday life in Texas.
Yeah, but you would agree that Graham v. Connor has nothing to do with 931 and 932, or the instructions the juries will be given as to what Texas law, how Texas law allows a justification for.
The facts of those cases do not, because that case wasn't a use of force where force was being used against the officer. Graham v. Connor just told us how we're supposed to analyze those use of force claims against law enforcement officers. But the facts had nothing to do with anything similar to this case.
But it did talk about the totality of the circumstances are important.
It did.
And I guess there was another Supreme Court case this year, what was it, Barnes v. Felix, right? It kind of expanded on that.
Yes, sir.
Right? And it talked about the totality of circumstances has no time limit.
It doesn't. That's why we're allowed to, in looking at that, that's why we're allowed to look at all of the factors that occurred, not just specifically at this moment. As a matter of fact, Barnes v. Felix was a case where the Fifth Circuit, we tried to apply that all we look at is that moment that the officers used force. That's the only thing that's important. The courts tried to narrow that use of force analysis to just that second when it happened and ignore the Graham decision talking about objective reasonableness. And of course, the Supreme Court came along and said, no, we're not going to look at just that one moment in time, that 1 second that Officer Villalobos was on the railing. That's a fact, but that's not what we look at. We look at, again, the totality of the circumstances, reaffirming that in analyzing use of force cases, we look at everything.
And in this case, tell me if you agree with me, these are some of those circumstances that can be viewed in the totality of circumstances in this case.
Okay, yes, sir.
These are things that, from your review of the records, your review of the testimony, so these are things that officers Villalobos, Alejandro, and Flores did know, right? They
Yes,
knew
sir.
that Melissa Perez was suspected of cutting wires to the fire alarm,
Yes, sir.
that Melissa Perez had thrown a glass candle at Officer Salinas as he tried to enter her home,
Yes, sir.
that Melissa Perez was not physically imposing given her size.
No, I don't agree with that.
You don't think they couldn't see her, how small she was?
I can tell you that they looked and saw her how small she was, but given the attacks that had been committed before they got there, then I don't think that's reasonable to assume.
Okay. That Melissa Perez was repeatedly telling officers that the whole world and all of America was watching them harass her.
Yes,
And that she was indicating that there were cameras everywhere.
yes.
And that Melissa Perez, against overwhelming odds, defiantly and repeatedly insisted that officers had no right to enter her home without a warrant.
As I stated, that was the comments that she made, but they have to be taken in the proper context. You have no right to arrest me.
She was saying that, right?
Yes,
Right? That the old man in the bed, that there was an old man in the bed in an adjoining room,
yes,
right? That although her front door was locked, 5 windows to her apartment were open and unobscured.
yes,
That officers were aware that she only showed aggression to those who tried to enter her home,
she attacked those that tried to arrest her, yes.
but not those who didn't,
There was nobody else close.
right? Well, the ones who were standing outside the railing.
Okay,
Okay. That officers had available for this entry and apprehension 15 fit, well-trained officers with body armor, multiple tasers, a shield, and a shotgun with beanbag rounds.
I do not agree with that statement. In certain parts of it, you're right. There was a shield present. There were shotgun, less lethal shotgun was present, and there were 15 officers that were present. However, only
Well conditioned?
they were well conditioned, and you know what? Those well conditioned officers did not take part in trying to arrest Melissa Perez. Only two.
Only two. That officers had, before they made this entry, they had cover, distance, and time available to them.
We always have cover, distance, and time available until we decide to take action.
That their objective was to complete the entry and extraction without anyone being hurt or killed,
That was the objective, yes.
right?
Yes,
Isn't that, shouldn't that always be the objective?
it should, yes.
Right? Right.
Nobody wanted this to happen.
That at the time of their entry, they knew that she was within steps of being able to get the hammer.
Yes. But she didn't have it at the time they made the decision to go.
That knowing all of this, Villalobos and Flores attempted entry into her home without using the protection of a shield or meaningfully deploying a less lethal option.
That is a question that you're looking for to fit your narrative, but we've already discussed that those options would not have applied in this particular case.
You say the shield would do them no good.
I would say the shield was not designed for what the purpose it was, and going through that door with that shield would have been more problematic than not.
And you would agree, these are your opinions.
These are my opinions based on my expert analysis of the case.
I agree. And Detective Soto can have opinions.
I try to be politically correct here without actually saying it. He can have opinions, but his opinions have to be based on the law, and they were clearly not. Mine, sir, are.
Chief McManus can have an opinion.
Chief McManus can have an opinion. In this case, it was clearly wrong because there was no justification for it.
His command staff could have an opinion.
Again, same argument. They can have an opinion, but it was not based on a thorough and complete investigation of this case.
You would agree that from the materials you looked at, that Chief McManus and his entire command staff signed off on this prosecution, right? I'm not sure where you're going with that question. Yes, they signed off on it because they're the ones that initiated it, yes. Okay. But you would agree that that decision to sign off on it was months after the warrant was issued,
Yes,
right?
Yes.
It wasn't until September that the case even came to the DA's office.
just as the meeting at 8:30 relied on facts and circumstances that they did not have because the investigation was not complete, that rush to judgment there, okay, was problematic, as well as the flawed and incomplete, and I've already said it, horrible investigation into this case by Detective Soto that prompted this. What else would you expect them to do? They ignored the information necessary to make the correct decision in this case.
When you left San Antonio Police Department, did you do so on good terms?
Yes, sir,
Did you have
absolutely.
any problems with administration when you left?
None at all.
Very good. Thank you, Lieutenant. I'll pass the witness.
Yes, sir.
No questions, Judge.
No question, Judge.
Mr. Sapone, does anything? All right, you're excused.
Thank you, sir.
Yes, sir.
Can I ask the state one question?
Sure.
7:05 on the next witness, if it is Mr. Villalobos.
Can we have a break, 20, 30 minutes? There's some materials we need to review that they just gave us.
You are coming, Coach.
Yes.
10:30.
in the morning. We anticipate going 10:30, and I know that one or more of you have to leave by 4:30, so that'll be about the time that we'll go tomorrow. All right? Have a safe evening. See you tomorrow.
All right for the tree?
Are these two your marks?
Yeah.
Oh, okay.
One of the jurors is gonna leave because she said she told her husband to pick her up by 8.
Does she have an extra taco?
I'll ask.
No. Or a donut or something? Bear claw?
So I'm gonna go ahead and start putting this up while we're waiting.
Yeah, I can start
I
doing
don't think
that.
they need it.
No, they won't. Not for the expert. the court reporter, please.
Yes, my name is Angelos Leiloglu, and it's spelled Angelos Leiloglu.
All right. State.
Good evening, sir.
Good evening.
I am looking at your resume. You have a Master's of Architecture from Texas A&M, a Bachelor of Environmental Design also from Texas A&M, correct?
Yes, sir.
And your field is photogrammetry?
Yes, it is.
And if you could tell me what that particular field is it suggested that it hard science based on a look at your educational background?
Yes, photogrammetry is the science of attaining accurate and reliable measurements from photographs.
Okay. And what is the underlying science behind that ability to obtain accurate measurements from, this is still photographs?
It can be, yeah, they're all still photographs. Of course, a video is just a series of still photographs, so
Okay.
it can be used on video as well.
What is the underlying science behind that whole field? How is it applied?
So it's applied by using two things. One is the principles of perspective, developed in the 1400s, and an area of math called projective geometry.
And how do those two areas, how do they come together to allow you to obtain, I'll ask your forgiveness for the late hour,
No problem.
obtain the desired information?
Yeah, so it's through triangulation. We're trying to measure points. So by being able to view a point by two different directions, we can triangulate its position in 3D space.
Okay, and then once you have one point, you determine another one, and those become known locations, and then you associate them all in a particular area, I'm assuming.
Something like that, yeah.
Is there a specific technique in applying that theory? How many different theories are there in the process of achieving your end state? Is there just one that's commonly accepted, or are there alternate and competing theories?
No, they're not competing theories. I mean, it's basically math. So it's
Okay.
like you get it right or you get it wrong.
All right. And the field of photogrammetry, how long, I've heard about and seen your recreation of the JFK assassination. Is that where else is your field used? Besides that recreation that I've seen you do?
Oh, I do that every day on a daily basis. That's my expertise.
What are the tools you use to complete the calculations and produce your finished products?
So there's technology that we use, LiDAR. You've heard the Leica being spoken about. That's our base. That's a device that captures a million points per second. So you have all this data, and you apply that to these photographs so that you can get to within millimeters of accuracy. What we're doing is trying to do, it's called reverse projection. So we're trying to take a 2D image that we have, it's a photograph or a still image from a video, and we're trying to project backwards to find out where that camera that took that picture was. And then from there we can look through that photograph through the lens of that camera, and then we can recreate or reconstruct what was seen in that camera itself.
Now, we've already heard, this jury's already heard testimony about how the body camera, which is the source cameras for the videos, which are the still photographs you had, it has some inherent error in its lens. How do you account for or remove that error from your original still photograph?
Sure, that's called camera calibration, and part of photogrammetry. And so it's going to first calculate that lens distortion, is what you're talking about, and then correct for it.
Okay. And so these are all commonly accepted practices within the commercial world in the field?
Yes, sir.
And that commonly accepted practice, it has, I'm going to assume it has specific methodologies that you have to follow to get your end state?
Yes.
And you've applied those in this instance?
Yes, sir.
What information did you look at to start inputting to develop your finished product? What information were you getting?
I was given body-worn cameras, scene photographs. You're saying that I actually used or just that I've reviewed?
What you actually
Actually
used
used.
and reviewed?
Reviewed, I was given also some 360-degree images that were taken by the SAPD. I believe that's all. You know, there's photographs of the weapons. There's photographs of the officers, things like that.
You said a 360-degree images taken by SAPD?
I believe they're SAPD, yes.
Do you have those images with you?
Don't know if I have them with me. They're called OSCR 360.
Okay.
Yep.
The OSCR, thank you.
Yes, sir.
Once you get your raw material, once you get your material, what's the process you go through? You calculate those known distances, and then what happens?
So first we have to have a base, and that base is the Leica scanner or 3D laser scanning. It's not a Leica that I use, but it's a similar device. That's our basis. And like I said, it can capture 1 million points every second, all accurate to within just a couple millimeters. So that's our base. You have to know some known measurements of the scene, and then you can apply photogrammetry using that data to come up with the reconstruction.
The Leica scan, did you do that yourself?
I did. It's a LiDAR scan. I used a Trimble scanner. It's a different brand.
All right.
Mm-hmm.
And it's your testimony that you applied those techniques properly in this case?
Yes, sir.
One of the charts that's been given to us to review, you produced a point of view viewpoint from Officer Alejandro. He was the officer standing on the ground outside the rail. You remember those?
I do.
Now, I'm curious because from his body-worn camera, he's standing on the ground beneath the concrete platform. His body-worn camera does not show his weapon or aim point. So how were you able to develop, how did you account for the in-state product where you do have his weapon and aim point?
Yes, sir.
How did you compensate?
It's not compensation. It's been recorded by other cameras, other body-worn cameras. You can see him in multiple cameras, so you can then triangulate his position of his weapon, position of his legs, position of any limb on him, his head, all that stuff is triangulated because there's multiple cameras.
Okay. We've heard testimony about how an officer's stance, aim point is common sometimes to have both feet aligned. Some may prefer maybe to blade themselves slightly. I'm not aware of any body cam that shows Officer Alejandro's feet all the way down while he's shooting. How did you account for that from the other cameras? I know the principal one would be Thompson to his left, you've got officers behind him.
Correct.
But no weapon, you can't see his feet, at least to my knowledge. So what all went into giving the rendition in your finished product for Officer Alejandro's weapon and point of view?
For his weapon or his legs?
Well, you'd agree that knowing his feet, that would help support his point of view for his weapon. And I'm simply saying, I don't know how you got it. So did you have to make any estimates, or is everything still precise? Do you have any variables? What are the variables that are on there?
Sure. So, for example, like if we know where a hammer is, and we can't necessarily see all the arm, we know at least the hand is touching where the grip is, right, or the handle. So the same thing with the body. If we know where not the whole body is there, but a foot is on the ground, we can have a margin of error where, say, their legs are. But if we can see their torso, we can assume that's right underneath. So there's some, yes, for parts that we can't see and measure, we know his height, and we can use a average skeleton to try to match or track his position.
All right, so there's some margin of errors in trying to get his feet and his footing. Does that same thing apply for his arm length? Because again, I understand you can see from probably Officer Thompson's body cam, see where his weapon is, but did you also have to make, are there margins of errors in that calculation?
There are margin of errors, but so if we can see it clearly, the margin's smaller. If we can't see it clearly, then there is some margin of error that's calculated by the software itself. So I guess that answers your question. Yes, there is some margin of error, and in any photogrammetric analysis, there's going to be some margin of error.
And those errors, when they're identified, does the software fill in and compensate? Is there a printout where it tells you what those possible errors are? If somebody wanted to check it, how would they go about it?
Well, the errors are really on the calibration of the camera. So it'll tell you how well the camera has been calibrated. Then whatever we can see through that camera, we're matching where those objects are.
Okay. Has the end product that you produced or products like it, have they been used in courts in the state of Texas frequently, many occasions?
By myself?
Yes, sir.
Yes.
How many times?
At least 3 of them, I think, in trial.
3 trials. What type of trials are these?
2 of them are officer involved, and one it was a car lift accident, industrial accident kind of thing.
Okay. So, were they criminal trials?
Actually, I take that back. There's 3 officer involved and 1 car.
Where were they? What counties in Texas?
Tarrant County, 1, Dallas, and Austin. You should have my history, I think.
At least the document I'm looking at only shows your education, experience, paragraph on forensic visualization, research teaching, professional affiliations, publications, technical conferences. There's no mention of that I see off of this document, and that's the first thing I get when I click on your name, about using it in criminal trials in this state or any state. Is there something else I should be looking at?
I thought you'd be provided with it, but I have a copy if you want me to
Please.
grab it.
Please.
Judge, can I go grab it?
Yes.
Thank you, sir.
It's
back to that error rate, and I don't want to misstate. I did hear you say that there's a certain margin for errors for the things you can't absolutely know. Is that accurate, what you said?
Yes, so if we can't see it, we can't really match it. If it's not, whatever's seen in the footage, we can match. But if we can't see it, and I'm not sure exactly if Mr. Officer Alejandro's feet can't be seen, but like I said, we can make an assumption of where his feet would be, considering his size and where he's standing.
Okay. And what is that potential error rate or that margin of error? What is it?
I calculate it to be about 3 to 4 inches.
So you got body-worn camera footage, reports. Did you use still photographs as well?
I did.
And then you used the OSCR footage that was provided.
No, I didn't use that.
I thought you said you did use old.
I reviewed it.
Reviewed it.
Yes, sir.
From the charts that I've seen with the, is it appropriate to call it 3D simulation in your in-state?
I'm not sure what you're
I'm looking
describing.
Okay, I've been looking at what we were handed as a flash drive. It has approximately 81 PowerPoint charts, and the last 30 or so have what I'm calling a 3D animation or projection.
Sure.
That's the in-state product you created. Right?
It's a visualization, yes.
Okay. And I'd ask, with your opinion, how would this help the trier of fact reach a decision, your product? How does this help the jury reach an ultimate decision in this case?
Well, first of all, the reason I was asked and tasked to come up with the measurements, I'm measuring basically the reconstruction that's been created, is to provide one of the other experts information that he would use. I also think that being able to show from the officer's point of view what they potentially could see would help the jury in their decision making.
No further questions, Your Honor.
Did you want further questioning, Judge, or is that sufficient?
It's sufficient for the court.
Okay, yeah, we'll just save it for when we obviously proffer him in front of the jury. And then we intend to use his PowerPoint presentation as a demonstrative.
Okay. Anything else?
That's it.
All right. Tomorrow at 10:30.
No, that's for you. Yeah, cool. And Neil, wherever Neil is.
Excuse, Judge.
Yes.
Thank you. Have a
Yes,
good night.
sir. You too.
I'll just sit over here, it's fine.